I think John's coming. Welcome everybody to our meeting, and glad y'all are here. Why don't we go around for the record, and starting with Bob Miller, why don't we introduce ourselves for the tape recording? Thanks.
Bob Miller. Charlie Appleby.
Greg Smith.
Carl Cannon.
Greg Anderson, City Council.
John Wilbanks.
Bill Shy.
Bob Shercliffe.
David Bohr.
Kelly O'Leary.
Gwen Yates.
Tad Delagal.
Thank you. And I want to remind us and help remind me to remind speakers that we really need to use the microphones, particularly the one at the podium, because that sort of goes in and out. So if people are talking at the podium, if they could remember to stay close to the microphone, that would be great. So. Well, I wanted to just say a couple of things before we got started. Y'all have been reading the paper. We had our presentations from last week, and we have headlines like the Daily Record, Brown Gulliford set stage for major showdown. We have the newspaper with headlines about what could be the very fractiousness of this, and we're getting into the political season. And so we see and we read personal sort of attacks as contrasted with discussions of the issues. And I want to call us to a higher way of doing things. We just can't, even though we know there may be other agendas floating around, our agenda's got to be higher than that. So I want to call us to do that, and I was particularly reminded, Peggy and I were in Austin, Texas, and San Antonio this weekend, and we went to church. And I'm not making this a church thing, but in the confession of faith that we read, it so told me what was going on here. So I just want to read 3 or 4 lines from that, just to remind us, to call us to a higher way of doing things. So. We confess that we remain preoccupied with ourselves, separated from sisters and brothers. We cling to destructive habits, hold grudges, and show reluctance to welcome one another. We allow the past to hold us hostage. So the promise is that we can get beyond that, and we really do. This task force has been great because we have not brought our personal agendas. And we need to keep focused on that. Even when we hear others, we need to remind them that we're here for the benefit of the city. It's a large issue. Some people have said it's the largest since consolidation. I will say that I was very disappointed in the tone of some of the rhetoric, because it's really a function in a way of the Sunshine Law too. Now, we all love the Sunshine Law, roll your eyes. But what it forces to happen is that brainstorming doesn't happen except in the public, because we can't talk with each other. So even though, taking the mayor's proposal as an example, that's a proposal. It's not a finished deal. There have been other proposals. We may or may not end up there, but we have to brainstorm those. Wayne Ezell sent us a link to Tom Majdanik's proposal before Stanford. I'm intending to ask Tom to come next week. I think I've looked at it. I hope you all will look at it ahead of time. There's some interesting things. I'm not sure about some of his assumptions and where he ends up, but we still need to hear that. But brainstorming is what we're about, and we need to remember that. So within us, let's don't throw stones, but stay on the issues. So I just want to remind us of our high calling in this. Moving on to our agenda, I wanted to go over the governance issues, and I wanted to tell you that what you have before you, John Keene and I have agreed on. So this is a negotiated, subject to his board's approval and subject to your approval, of course, and ultimately to the city council. But I want to tell you, John and I have striven to have a good relationship and to hold a higher agenda than beating at each other. So almost everything that we have designed, John has agreed to. There's some exceptions, but I'm hoping that we can come out of here today adopting the governance proposals. If y'all aren't quite ready to do that, we can wait till next week. But I'm just very thrilled, to say the least, that Mr. Keene, acting on behalf of his members, and I, acting on behalf of you, have come to this. So let me just go through it as a whole, and then come back to it and answer any questions and then discuss them. I've also, Jonathan Trichter and David Drain have seen this, and I know Jonathan's got some things, so I want them to feel like they're included in the discussion as we go on. So, if probably the easiest way to follow it is with the clean version, but the red line is here. The red line is from the draft y'all had last week. But I'm just going to sort of, from memory, go back through the clean. There's some, in the prefatory part, there's some rearrangement. The big addition to that is the recognition that the circuit court decision that Judge Wallace entered is now the subject of a motion for rehearing, which the pension fund has filed and is joined in by the city. So, and that may, the notice of appeal period runs out in a few days, so that probably is going to be the subject of an appeal. So that's still an if, but we have to take that for where we are, because we can't wait for the District Court of Appeal. But that's something that suggests to us. Recommendation 1 is the all-important professionalized financial investment advisory committee. It is virtually unchanged from what we have seen before. It is both a financial committee and an investment committee with powers. The most significant change is Jonathan Trichter had proposed that there'll be a double-blind sort of thing where, in terms of investment managers, that if the investment committee did not approve it, that it died there instead of going to the board. John Keene felt that the board has the ultimate fiduciary relationship. If the process is transparent and works, then that should not be a problem for us. I think if we were sitting on a board with ultimate authority, we would want to have the ultimate authority too. So that double veto is out, but the whole transparency, the election of the committee, the nomination and approval by the city council is in there, so that gives the governance control to the city council, which is very important. The black line on page 2, the parenthetical, is a suggestion that David Bohr raised. John and I talked about that, and I've also talked with John Trichter about it. I want to come back to it. But whether that's a good idea to go back and waive conflicts, what the press might do with that, we need to discuss that. So the investment committee is and that solves a lot of problems. It's a strong committee of professionals with election rights or approval rights by the city council. The ethics section virtually is unchanged.
Bill, the approval rights are for 2 of the members, right? Or all 4 of the members?
On the investment committee for all of the members.
Overall, but on the trustees, 2 of the members.
On the trustees, 2 of the members, right. But on the investment committee, they're nominated by the pension fund board and approved by the city council.
Bill, can you speak to the term of those members?
Yes, that's unchanged. It's 2 terms of 3 years.
Should there be discussion about lengthening that? Because these are...
Yeah, let's come back to that. Let me just get through it, and then, yeah, this is not a closed discussion. I don't mean to say that it's a done deal, because I can't make decisions for you guys. I wouldn't want to. So, but let's come back to it. So make that note. So I just want to get through the whole document. In section 2, the ethics, certification, and disclosure, that's virtually the same except subparagraph C. John pointed out that they have a certification from their investment managers that they're not the subject of a claim by any present or past customer or by a regulatory agency. So I've added that, since they do that anyway, and that's a good disclosure anyway. Section 3, the use of the Office of General Counsel. Y'all will recall that the first sentence of that you saw before had a concession from the board that the opinions of the General Counsel were binding on all of the government, except as the Attorney General or Circuit Judge might rule otherwise. Where I ended up on that, because the board, as y'all heard, was not going to concede that. We just took it out, didn't agree one way or the other. So if it comes up and Cindy issues an opinion, for an example, then they'll fight that out. And the law is still the law, and it would still be construed. So we don't need to force that concession, it seemed to me. It provides that the board will retain its ultimate judgment as to its counsel, but there is a direction that the fund will use the Office of General Counsel for many of its ordinary and customary legal needs. The fund will consult with the OGC should it find that it needs additional or separate counsel. And then it acknowledges Bob Klossner and his firm and that their fees have been approved, and then goes on to say that the special counsel and the OGC will consult regularly about the needs of the fund. Next, on term limits for fund board members, John and I have agreed as to what you've seen before, that there would be term limits starting in October of a maximum of 2 consecutive 4-year terms. It also provides that the council-appointed trustees are subject to recall at any time by the council, which is the case now. Notwithstanding the 2 4-year terms, if the council wants to recall one, they can do that and appoint somebody new. It also, at the very end, we've added a sentence: because of the governance reforms as to board members, the term limits, that we would request the city council to modify its request to the legislature in the ordinance that they passed last week seeking to elect the 5th trustee, that they change that to request the term limits, the statutory changes that would do that. I've talked with Council President Gulliford this morning, and he's okay with that. But that's important, and I've told John Keane has asked, well, why don't they just remove that now? And I said, well, John, it seems to me that they ought to leave it until we get all this agreed to and passed by the council, because that leverage is important with the legislature. That bill needs to stay before the legislature as drawn until we get our deal done. That's very important. Next, the qualifications for the council-appointed trustees and the 5th trustee, that's essentially unchanged, with just the note that the council will continue to, that the 5th trustee will continue to be selected by a majority vote of the other 4 trustees. The actuarial standards, section 6, that is essentially unchanged, except to change the time period to 120 days. That's February 1st. The 90 days was put in there at Chris's request to try to get the information from the board earlier for the budget process. The city has not always furnished its information to the board, which was necessary for the board to complete its work in the actuarial analysis. So 120 days is fine. Chris is fine with that. And it also adds a sentence that requires the city to respond quickly to requests for information from the fund. But essentially, that's all the same. In J, there's an addition that you'll see that David Bohr had recommended, which gives some authority to use updated mortality or longevity tables. There is a black line in subsection L. John felt that in a sense it's a recalculation of the unfunded liability, and that's already provided for. So he thought that there would be too much information. I need to go back on the term limits. That John has said that he supports that and will push for that with his board, but he doesn't know if his board will approve that. So I need to That's one of the exceptions with this. 7, the selection of the future administrator chief investment office. That's essentially unchanged, except to say that they'll use the city's employee services department, which is the human resources department, and if necessary, utilize an executive search firm. John had pointed out that those can be very expensive. They're not opposed to using it, but they may not do that. And the city doesn't necessarily use that on all their searches. The guts of this came from the mediated settlement. John has said that he still has some issues with that because these same requirements are not necessarily requirements for various city offices. But I pointed out that this was part of the mediated settlement agreement, but that is a little exception to the approval as far as that's concerned. Future administration of the funds is essentially unchanged. There's an addition to, if it's permitted by law, when that system, the current system is closed down, that they could purchase annuities. I asked Chris Hand what as y'all had asked, what does the Florida Retirement System Special Risk Plan do? I really haven't gotten an answer yet, but he said essentially the same as what the special plan does. So that's an open item. Status of the 30-year agreement is essentially unchanged. Added 2 parts, mainly if Harvey Schlesinger dies or wants to quit, it provides for the persons that would succeed him to be of comparable experience, temperament, and community respect. It adds a section dealing, well, it changed, this came from David Drain or Jonathan Trichter, I believe, that, or no, it came from David Board, that we can't be asking Judge Schlesinger for an opinion as to the fund's performance, but he can determine his opinion as to whether it's, what were your words, whether it was...
Have him serve for purposes of making a robust inquiry as to whether folks have demonstrated the wisdom of what they're doing, as opposed to forcing him to have an independent opinion himself on that topic.
So that's what that language is all about. It ends the 30-year agreement in September of 2024, which is 10 years, but it continues the monitoring until the later of 80% or the end of the agreement. And that reversal is important because we need to continue the monitoring even if the agreement itself has ended by its terms. Consultation is unchanged, expression by charter ordinance. You might know notice in the first section, I changed that from amending the charter to amending by ordinance. That means we don't have to go to a referendum, and the council can change by ordinance to add the investment committee, which will save a lot of time and effort and expense. Paragraph 13 is new. John felt that the investment committee, the ethics and disclosure requirements, and the standards for actuarial analysis, what was good for this fund should also be good for the general employees and the correctional officers' funds. I talked to Joey about that, and Joey doesn't have any real objection to that. There's some, in the nits and grits, there'll be some slight differences, but the concepts are okay. Then I've added what was very confusing to me. Exhibit A is the investment authority. This comes from the various statutes. It still needs to be vetted more carefully, so I've just added it so it gets in here, but we shouldn't adopt that today because it really needs to be vetted by council to make sure I did it right. It does add on the final page what the bill is before the Rules Committee and the Finance Committee and the one other committee of the council to add for alternative investments, except for hedge funds. The council, when it adopted that amendment in the Rules Committee, said hedge funds are prohibited. But it's my experience that I don't even know what a hedge fund is anymore. It used to be a particular risky sort of investment, but now a hedge fund is sort of any private investment vehicle. So there needs to be a definition of hedge fund, which is beyond my MOS. So that's where we are. I'm just, John, have I covered all the, and I have to say, John has been so cooperative. It's not to say John has been a pushover. I hope I haven't been a pushover. I think we've come to a fair agreement, a strong agreement for the citizens. But John has been notable in his willingness to go the extra mile. I might also say that John's executive assistant died very suddenly this weekend, for which it was tragic, but that's a real loss for John and his staff. They've got a very small staff, and we commiserate about that with you. I might also point out Ron Littlepage's mother died Friday or Thursday, and so in Austin, and we give you the same sympathies. So, John, did I state everything pretty much like we talked?
Pretty much.
Right.
I have a few comments at the appropriate time.
Okay, doke. So, questions? Why don't you give your comments now on the governance? I know you have some comments on the pension stuff. Do you want to, but on the governance itself, why don't you do that? Right. Hey, Bob, glad you're here. Great.
Good morning, Mr. Chairman and members of the task force. As the chairman just reported to you, we're in generalized agreement on many of the concepts here. Part of the financial investment advisory committee was language we sent over to the chairman at the very beginning. Having additional folks to look and get input from competent, qualified people always is a good idea, we think. The concept of how the committee's going to operate has been changed some because the Board of Trustees retains ultimate authority in the management of the fund. I can talk louder.
I can hear that already, makes it.
It's good to have good help. Thank you very much. So the duties assigned to the financial committee are fine with us, and we think it's a good idea. Much of this ethics we already do, so we don't have any problems with that. The revised language for the Office of General Counsel is fine. Now the issue with the terms of the board members, that's not fine. And let me tell you why. The Florida statutes permit the city council to remove either or both of their appointed trustees whenever they want to. And 2 years ago, they did. The elected trustees by the members are police officers and firefighters. They are not term limited by the statute. And for members, police and fire members, when they elect a trustee who's doing a good job for them and protecting their long-term financial future, they're not interested in that individual being removed after 8 years. I would note that the financial committee gets to serve longer than the proposed for the trustees. They get to serve 9 years in the proposal. Anyway, the statute does not contemplate a term limit for the elected employee members or the fifth member. The Attorney General has issued an opinion to help our good friends in Miami Beach. They raised the question last year. They wanted to have some special provisions for the fifth member. And she said, have all the special provisions you want for the two city appointees, not for the fifth member, not for the employee member. That's Attorney General Opinion 2012. In just a minute, I'm going to tell you the other number. One of the things we've done here is we have a lot of paper here, but it is 2012-05. That's the Attorney General's citation. So the term limit is a serious issue. So that addresses our concerns in number 4 and number 5. the transparency and actuarial standards. Our board's already on the one-year program. It's kind of a catch-22 situation. The statute provides that actuarial evaluations are required every 3 years. And that was the program we were on, but we changed 2 years ago to annual. So you have these people on this side that say, you know, we want these annual evaluations. We want this information quicker. You got the people on the other side saying, why in the world are you spending all that extra money? You did 2 extra actuarial studies you didn't get. And so the people in the middle, the trustees, can't win. You just can't win. So you have to do what you think's right, and we're on the one-year program, and away we go. The selection of the future administrator, that's provided by statute. It gives the board the authority. We have worked closely with our business partners in city HR over the years in filling all the positions that we have at our office, and we have no problem working with them. Going out, hiring a nationwide search firm, they generally charge between 4 and 6 months' salary plus expenses. There have been numerous occasions here recently. Most recently, the chief at Jacksonville Beach, after a nationwide search, they found a new chief hiding in the assistant chief's office. He was right there the whole time. And over at the JEA, virtually the same thing happened. They had a nationwide search, found somebody somewhere else, and he came and left, and a good long-term employee of the JEA was now put in charge of running it. And nationwide searches don't always find the diamond in the rough. Sometimes the diamond's already here. So that's going to take a little more wordsmithing on it. I'd recommend the board support the closure of the senior management plan only to remove irritant that has been artificially introduced into the conversation. We have been demonized. Myself personally have been demonized. Every city employee has a pension. Our elected officials are entitled to a pension. Some did not join the FRS, but they are entitled by law to a pension. And to decide that somebody that's worked for the pension fund for coming up on 24 years shouldn't have a pension, it's just terrible. But in the interest of trying to be cooperative, I would recommend to the board to close the plan on the last payday of September or thereabouts, and either commence the distribution or purchase annuities, whatever is best advised and recommended to us. The proposal that the next administrator not have a pension is absolutely not acceptable. If you're going to do this wide-ranging search to get somebody, long-term financial stability would certainly be uppermost on somebody's mind. So that can all be resolved. That's a technical thing that can be resolved. The status of the 30-year agreement, it runs until September 30th of 2030. The board is willing to talk about some changes in it and some tweaks in it. But in the meantime, much as you describe the restrictions that you operate under because of Judge Waddell Wallace's ruling, we have a settlement agreement that governs not only our conduct, but the city's conduct until that is resolved. Consultation among parties, it's already required by the charter and the terms of the settlement agreement. And as a note, on Monday, after Mayor Brown became aware of the untimely death of Robbie Gorman, he stopped what he was doing in his busy day and came by to see us and express condolences to me and to the staff. So the idea that some people harbor somewhere in the deep recesses of their mind that we're over on the corner of Main and Adams fighting with the people on the fourth floor over here is just absurd. But it's an idea that's been perpetuated by many. It's a myth. It's kind of maybe like the headless horseman. You just can't get rid of it no matter how untrue it is. So we do consult, and I did speak with the mayor about launching a series of pre-selected, pre-arranged meetings, but both the mayor and I agree that the timing of that should be after this body concludes their work, because we don't want somebody to say, look here, they've gone off and done something else. We commend you, Mr. Chairman, for making the change to do this by ordinance. Making some of these amendments to the charter either requires a legislative act, and then you're going to get caught in a timing thing, or a referendum by the people. Both of those are time-consuming and costly, and an ordinance would be much better. The generalized application to the city, I kind of like your explanation. You know, we got $1.4 billion over here. They got $1.9 billion. If having an extra set of eyes is such a good idea for us, probably a good idea for over here. And knowing that the chief is for it probably means everybody in his army is going to be for it. Now, there are a couple things I'd like to point out to you that was mentioned last time in the presentation by Pew, and it looks like it's going to be in their recommendation again today. The use of this chapter money, the 175 and 185 money. For years, between 1939 and 1987, our city fathers and mothers thought of that money as their money. So if the city was required to make a contribution of X, when the state check came in, they put it in, subtracted it from X, and then put the balance in. That's contrary to the statute. And it was contrary to the statute, and that's what led to the court case, which led to the 1991 settlement agreement. The use of the chapter money, both in 175 and 185, is governed by the requirement that the members get to vote. The members can vote to either put it into the main corpus of the pension fund where it becomes an integral part, or it can go into a separate share account, which we have the proposal before you. Statute's clear. It's to provide extra benefits. For years, people didn't know what extra benefits mean. They said they didn't. So the legislature helped them out. They define extra benefits as benefits in addition to or greater than those provided by general employees of the municipality, in addition to those in existence on March the 12th of 1999. So the plan to use our reserve that was proposed, is of serious legal issue. And since the city, in their wisdom, has extended a substantial number of benefits to the general employees, the 4% that we have been paying into the pension fund from the 175 and 185 money, as voted by our members, is now also somewhat suspect because of another Attorney General's opinion that said If you buy extra benefits and then the city gives them to the general employees, they're not extra benefits anymore. And that money should cease. Our members pay directly 7% out of their paychecks. From the reserve account, the chapter funds, we pay 4%. Any way you cut it, the pension fund's getting 11% from each one of our members. And it's disingenuous to keep saying the members are only paying 7. It's a shame they're only paying 7. Well, they're not paying 7. Our current members are effectively paying 11% into the pension fund. And we know as this work continues forward and winds down, that will probably be clarified. So with those comments, I want to assure the members of the task force that, again, our members appreciate your work. I mean, you know, this is a day to be inside. Y'all have struggled through the elements to come down here and serve the city that we know and love. We also agreed with the recommendation that the Financial Advisory Committee pool be extended to the 5 surrounding counties to pick up many knowledgeable people who would otherwise be prohibited from serving. The City Council currently has an ordinance before it to remove the residency requirements that they put in a couple years ago. So this recommendation then would not be in conflict with the overall City Council idea that everybody needs to live in a community inside the city limits that has anything to do with the government. Our board is very responsive and is willing to undertake and consider the final product that y'all come up with. But we do want you to know there are issues on the selection of the executive director, as well as the future use of the chapter funds, and of course then the term issue. All those have to be changed by the legislature as a general law, which is no easy task. There are provisions currently in both 175 and 185 that say certain of these provisions apply to all the funds. They apply to Jacksonville. Changing that is a high peak that has to be crossed. Senator Ring has been champion of municipal pension reform during his first 2 terms in the Senate. He's had a lot of hearings. He's the chairman of the committee. His legislation has not been enacted. He's trying again this year. And unfortunately, the League of Cities is against some of his provisions. And so that's the situation the members of the legislature find themselves in. Somebody shows up and says, this is really a good idea. And you say, okay, I'll introduce it for you. And they introduce it. And from here, there, and everywhere, high and low, come people forward and they say, Senator, how could you possibly consider something like this? And I said, well, he explained it to me. It sounded like a good idea. And they said, let me tell you why it's a bad idea. Very few people are going to support a carve-out for Duval County in this chapter money, because there's so many provisions of the chapters that would have to be amended. It's not just changing it in one place. So I do warn you that's a very difficult thing. But overall, it's been a pleasure coming over here and seeing y'all, despite the weather, and working with the Honorable Chairman has been a continuing good experience. Thank you for the opportunity to speak with you all this morning. We're available to answer any questions that you might have. And Tad has one.
I just wanted to point out, John and I have talked on the statutory stuff. There are different legal opinions. You know, we've got John disagrees, and I think Bob probably disagrees about the deemed to comply. That all runs into this.
Yeah.
These changes would be done statutorily by the legislature, or to the extent they amend the charter, can be done by the city council with a referendum. Now, I know there are different legal views about that, but that's what we have to consider
Right.
in our recommendations.
Let me respond to that.
Sure.
In 1999, the legislature did a major rewrite of 175 and 185. One of the provisions contained in both of those statutes is that members of the respective pension funds who served 10 years of service and were 55 years of age could draw a pension. That was something we were entirely against. And it was in the proposed law the two previous sessions, and we managed to defeat it. So on the third try, they said, what's it going to take to get y'all to support this law? I said, you have to exempt us from the retirement provision that people can retire after 10 years. Well, we don't want that. And so that's what they came up with these things. And so it says funds that were created by the legislature before a certain date in 1939 are deemed to comply. That was in 1999. You'd be amazed that people could come up here today and say, well, they're deemed to comply. You can change their retirement benefits to zero, and they're still deemed to comply. That's not the way the legislature meant it. It's not in the words of the staff reports and what have you. But it's a good thing for attorneys to argue about. As to us, we know how it happened, when it happened, and why it happened, because we were there when it happened. We drafted that language. We know all about why it's in there. And it was to, after many discussions with then Mayor Delaney and the leadership of the city council, they said, you know, you try and get a bite of the apple here, and if you don't get what you want to run over to Tallahassee and get them to change the state law. I said, hold it. You need to look. We're trying to keep them from changing the state law where you have to pay millions or more out in pension. And when they saw it and read what we had been working on, they thought it was a wonderful idea that we were over there fighting off the enemy. But that's what it's all about. You're right. Lawyers have different opinions, and that's why the city has its lawyer, and they have their outside counsel, and we have our lawyer. And the city council now has their lawyer, so there's lots of lawyers. But
Let me just go through, and John, as I understood it on the term limits, you had indicated to me that you would support that, but your board, you didn't know on the term limits provision for the board.
I don't think the board's going to support that.
Okay.
I don't think they're going to support that.
But
I understand why you're recommending it, and that's acceptable to us. But you need to know that I don't think they're going to support that because it's contrary to the statute. And the most recent Attorney General's expression, Attorney General Bondi, she told the Miami people, you can't do this.
But to the extent we change the statute, that's...
If the statute's changed, you know, everybody has to comply with the statute. We're for law and order. Half of our members carry guns to work and they enforce the law. So, you know, if they change the statute, they change the statute.
But
I'm telling you, I don't think they're going to do
Yeah,
it.
but the statute includes the charter. I don't want to get into a legal argument.
Oh, yeah, you're going to have to amend general law to change that, and that's not, we don't believe that's going to happen.
Okay. And then on the end of the 30-year agreement, you and I did indicate to each other that 2024 was up.
Well, I would strongly recommend that if all these other provisions that we support are adopted, that the board move forward to reduce the term of the current settlement agreement by 5 years or so. Yeah, so yeah, we're willing to do that.
Okay. Great. Questions, Ted?
Yeah, just a couple of questions on.
Hold on
the
just a minute,
savings.
Dan. Let me clarify that. I'm willing to strongly support that and urge that to the
That's
board.
what you had told me.
Uh-huh.
But I understand that the city council may not approve that, this committee may not approve it.
That's
the
right.
board may not.
That's right.
Right.
But right now, we all kind of marching to the same drum. Ted, thank you.
Yeah, one of the things that I wanted to tie in on, and this may be something for you to look at, Bill, I think Bill you're under the conclusion that if the city council changed the charter, that would change the statute.
If there's a referendum, the charter provides that they can't do it by themselves.
Right, because if it deals with employee benefits, there has to be a referendum to change
That's
that.
correct. No question about it.
Now, with regard to some of these provisions, if, for instance, we came to an agreement and the board was comfortable with that agreement, specifically with regard to the use of the chapter monies, okay? And using some of those chapter monies to pay down the unfunded liability. We're all in this together. We're trying to come up with some good outcomes for the future, and I know that that's going to take some sacrifice from all parties, and the fund is.
Ted, speak into the microphone.
Yeah. The fund certainly evidencing a willingness to do that. But let's say that there was an agreement. What is your position as to whether or not a special act of the legislature could be passed to address the use of the chapter funds to help pay down the unfunded liability, if that was part of the deal?
I think it's dubious that you could get it passed this year because time's running against you.
Right. If all parties got together,
Right.
and did something fairly quickly, I think.
Let's go back to the chapter funds for just a minute. This is this little pot of dollars that Uncle Florida sends over here. We use part of it to pay a bonus. It's called the Payton Plan bonus because it was enacted under Mayor Payton. If we change it somehow, it may become the Brown Plan bonus, but whatever. Or the Shy Plan bonus, who knows? But we use part of that money to send a bonus to our retired people. And that's part of the money they were entitled to all those years. So all of it cannot be committed going forward.
Right.
We have an obligation to the people who came and served and who were the mortar that kept the bricks of our community together. So
And I
we're definitely not going to give it all away.
I understand there's a lot of details, but
Right.
I know what the city's contract attorney said about the deemed to comply.
Oh, yeah, that's-
The plain language of the statute doesn't say that.
I know.
And I understand that, but
That's
if we're
fine.
going to try to do something here for long-term, I think that it would be important to get a deal from all parties and then figure out a way to make that deal enforceable long-term. And I'm just thinking maybe a special act of the legislature may be the way to do that.
Right. Let's talk about long-term. The proposal for the pension benefits for the new people, they're going to get much less than the current people. So they're going to get less. You want them to pay more, and now you even want them to pay more. The proposal that was up here previously was the city would be paying 6%, and the members would be paying 10 out of their pocket and another 8 or 9 out of the chapter money. Well, has anybody seen any shared sacrifice in that? When the employee is paying 3 times what the city's doing?
Yep. Let's, Ted, and John, let's hold the pension discussions on the design of the pension to another day. Because I really, to the extent we can get on the governance, I'd really like to do that. Now, y'all may not be ready to do it, but if we can discuss that, then there'll be a time to discuss the benefits side.
That'd be fine.
And the unfunded liability side of it. So
That'd be fine.
let's come back to the governance stuff, because if y'all have questions or concerns, then that's where we need to focus.
Just on the
Dave.
governance topic.
Yep.
I think it's great that you guys have sort of worked out a lot of the issues. I think, and this is going to sound a little bit harsh, and so but I don't intend it to be. I'm trying to be a principled comment here. You know, in a large sense, the defined benefit plan is a dramatically powerful tool, okay? We've also demonstrated that it's dramatically complex, and things that you don't appreciate can have huge impacts, right? As we think about setting the ship going forward, I think it's important to recognize that there's really sort of a fundamental question at the beginning of all this, right? And that is the way the defined benefit plan is established, the city underwrites all the benefits guaranteed. And employees make the decision to say, this is great, this is powerful, I'd like to put my money in there too. And in comparison with the alternative, which is an employee-based pension plan that's a defined contribution plan, the chapter monies could go into, that the employee monies could go into, we instead say, if we adopt a single defined benefit plan, that you know what? We'd rather not do that. And we'd rather throw our lot in with the city. And it's powerful not only because of what it can do for earnings, but it takes away all the pressures associated with, you know, an individual in the market not having the expertise. But ultimately, it is a city plan. It's not a joint plan. It's not. It feels like an equity that what we really ought to have is we have employees putting their money into the defined benefit plan. Shouldn't we get an equal right in all of this? But that's not really what we're doing economically. We're having the city guarantee and underwrite the plan with participation by employees. And so as we look at the question of governance, right? And we look at the question of the fifth member, and the mayor said we really think the fifth member ought to be identified by the mayor's office. And we look at the question of reducing the use of council, and we look at the question of the double bind and getting rid of that. I think we need to also think about that ultimately this is not a joint arrangement. This is a shared arrangement, but it's a city's plan provided for the benefit of those to participate in. And so I think it's not, I just would like to make the point that I think it's not an even-sum game here. By its nature, it needs to be a city-controlled product with visibility and transparency and input, but it's ultimately a city product. So.
Great, thank you.
And only the city can create the benefits. Pension Board didn't create any of these benefits enacted by the city council and signed by the various mayors. We subscribe to that. We agree with you.
Greg.
I don't really know how to follow that. That was a great way to start. Thank you. John, I think I've mentioned this in the past. I struggle a little bit with the idea of fiduciary responsibility and specifically related to the chapter fund. So my question really is specific to the responsibilities that the current trustees have related to those chapter funds. Do they have the ability to determine how those chapter funds are being used?
The statute and the citation is 1753511. It says if the municipality has a pension plan for police officers and firefighters, which in the opinion of the division meets the minimum benefits and standards set forth in this chapter, the board of the trustees of the pension plan, as approved by the majority of firefighters and police officers of the municipality, may either put the money in the pension plan or in a share plan. The members get to vote on the use of this money.
Okay, I thought I heard two different answers in that. So really, and John, I have the greatest respect for you.
Thank you
for all your hard work, all this time in participating in this process. But I'm to the point where we just need answers.
Okay.
So do you believe that the trustees can direct those chapter funds or not? And it's just a yes or no.
No, they can't, except with the approval of the members. And that's how we got the 4% that's going in now. We put the question to a referendum of our members, and they voted yes. And that's what we did.
And so if the trustees said we should use this money because we've got a big unfunded liability, the members could say, nah, we're not going to do that.
They could. That's called democracy, but they probably wouldn't.
Right.
They probably agree with the board, in other words.
They probably would. We would think so.
Okay. And so that's really the struggle that I have right now. We've got a huge unfunded liability, and we're talking about sustainability of a plan. And if you can make those contributions to improve the sustainability of the plan, isn't that the higher fiduciary responsibility of the trustees?
We think that the fiduciary duty of the trustees is to maximize the value of the plan and reduce to the extent possible the cost of operating them. That's in a nutshell what they're supposed to be doing,
Okay.
and they are.
And I agree with you then. That's all I got.
Okay, thank you. Other questions?
Let me just ask one question. On the term limits, in your experience, does it take the police officers and firefighters who are elected a good amount of time to get up to speed on these issues and to be trained to serve on the Board of Trustees?
It does. It's very complex. That's why there's not a lot of financial advisors and people with financial expertise in the phone book. There's a lot more plumbers and carpenters. But in our case, longevity plays an important role in it. The board is statutorily required to meet quarterly. We meet every month, so we meet lots more. But nevertheless, I will tell you about my very first pension board meeting back in the 80s when I was on the Board of Pension Administration. Actually, I thought we was in an algebra class when they were talking about alpha and beta and things like that. But I was assigned to Fire Station number 9, and they sent the quarterly reports out. And so I looked through them, and I was a junior guy, first meeting, so I had me this long list of questions, which I thought that's what you were supposed to do. So I arrived at the pension board meeting, which at the time was held on the 5th floor of the old city hall. There were 9 people on the board. 7 of the chairs had the stacks of books in front of them. They had not been sent out to those other trustees. So I told the chairman, I said, I'd like to ask a couple questions when these fellows get through with their presentation. At the time, we had 4 investment managers. They served the police and fire and the general employees both. The funds were commingled for investment, but accounted for separately. And so the chairman had the presentations, and he said, I have one question. And he asked each one of them the same question. Do you have more money now than you had at the start of the quarter? And when they all said yes, he said, you're doing a great job. We'll see you in 3 months. And so they departed. When the meeting was over, I said, Ray, that was his name, Ray. I said, Ray, told you I wanted to ask them fellows a question. He said, I know, but you're the new guy here, and I didn't want you to look foolish. Tell me the question, I'll give you the answer. I said, one manager is selling Standard Oil, and the other one was buying it. And what did one know the other one didn't know? He said, I don't know. I said, I know you don't know. That's why I want to ask them. So you need to call your buddies and tell them when they're here in 3 months, don't leave without asking me to have any questions. I'm the only person on this 9-member board representing half the money, and I'm going to ask questions. And he said, I'm going to get you the answer to that. As of today, he has not, and he's long gone. But that's what it's all about, you know.
Yep.
You have to ask questions and try and find solutions.
Sure. Okay. Let's go back to taking the sections, and let's see if y'all are in agreement with it.
Thank you very much.
Proposed. Thank you, John, very much. Section 1. And I want to call to your attention the highlighted area on page 2. As John and I talked about it, and David, you might want to speak to this since you had proposed it. Why don't you do that first?
Conflict of interest?
Yeah, this is waiving the conflict of interest.
I just thought that the conflict of interest is there for good reason. There may be some instance where actually the thing that's causing the problem is a little bit ridiculous or just not really an issue. And so should there not be some mechanism that parties could evaluate, this really isn't an issue, we think it's in the best interest, and we hurt ourselves by not taking advantage of the opportunity. And so, subject to the appropriate hurdle, there ought to be a way to address that.
And the hurdle is unanimous approval by both the Financial Investment Advisory Committee and by the board.
Right.
Separate approvals. So, in or out, y'all, what's y'all's feeling about that? I'm taking that as leave it in?
Yeah.
Is that, okay.
Should that be documented somewhere, the nature of that? Something in writing that was waived?
Yeah, that would have to be part of the
Then
transparent
it's-
public process,
yeah,
right,
okay.
yeah. Because they don't meet outside of the sunshine.
Right, so it'd have to be in the
So it'd be there.
minutes.
Okay, so that'll stay in. Any other questions on, yes, Bob?
I may be alone in this, but up there in the term for the investment advisory committee, it calls for 3 years, 3 terms, 9 years. And then a year off, and you can come back for another 9 years. My experience with many, many boards is that when people come back after 9 or 10 years service, they're never as effective as they were before. It's just, I don't know the reasons, but this advisory committee is really important. And I think occasional turnover is good. And I can't imagine the day when we have these board members all having been there for in excess of 9 years. And, change is happening quickly these days, not only in the investment world, but in governance. And it seems to me that 9-year term should be sufficient, and I personally am against coming back on the board after a year's off.
Is there any support for amending it to delete that? Bob?
Yes.
Okay, others? All right, Bob, I'm going to treat that as a motion to delete the coming back on section.
All right.
And Bob, that's a second discussion. We might as well be formal about it. All in favor of the motion, say aye. That was very weak. Let all opposed, let's see what that. All right, let's raise our hands. All in favor of deleting the ability to come back on, raise your hand.
In favor of deleting it.
In favor of deleting. 1, 2, 3, 4, 5, 6, 7, 8. All opposed. 1, 2, 3, 4. So it comes out. Okay. All right. Anything else on section 1?
This doesn't have I didn't see the term limits for the board members. That's not in.
That's not in here.
That's on page.
Charlie.
So later.
Charlie, by the way, I didn't put the 4-year beginning term because that was longer than the term itself. So that's why you see it.
Okay.
That's why. Right.
On the, I'm looking at the black line copy of this. The paragraph that begins on the very bottom of page 2 and goes over the top of page 3, it's basically the last paragraph of paragraph 1. It talks about basically the functions of the Advisory and Investment Committee. I agree with most of the changes, but it seems to me we get way too far in the detail here to say that the initial ranking of candidates responding to a request shall be performed by the professional staff and presented to the Financial Advisory. I mean, the Financial Advisory Committee should do what it wants to do and provide its advice. You're really restricting the function of the Financial Advisory Committee and saying that most of the work's being done by professional staff. I don't see the need for that. We're selecting people who are highly qualified, and they're providing advice. We clearly have provided that the fiduciary responsibility resides with the Board of Trustees, not with the Financial Investment Advisory Committee. Let the Investment Advisory Committee, they may very well request that professional staff do that. They may have a whole different approach. I think it's getting way too much in detail.
Okay. That would be what Jonathan Trichter would have recommended. John Keene said that as a practical matter, and he gave me a recent RFP, which was 30 pages long. It's pretty detailed. They had a significant number of responses. John Keene's point was that the committee didn't want to sit there for day after day after day to do it. So I think what you're saying, as long as this committee can determine the procedures it wants to follow, that's fine. And I think John would go along with that. I'm not going to ask him up because he might not. So what you're saying is let's let the committee decide its process.
Yes, I expect that's what will happen, but I don't think we should dictate that.
Okay. Is there support for deleting that?
Well, let me just ask a question. Would that be achieved by, instead of saying will and shall, just say may? You know, permit the committee to make that determination?
I don't think we need to be that prescriptive as to what the Investment Advisory Committee does. I mean, if they feel like that it's way too much information for them to spend the time, which they probably will, they will go to the then chairman and say, we need some help, and the staff will do that. They may decide that they don't need that. Let's just let them make that decision.
Well, no, but at least having the word may in there will authorize them to make that election if they can.
Let me cut through it. The previous sentence says the committee will work with the fund's investment consultant and the fund staff to rank all the blah, blah, blah. If we it gives them that power.
Right.
The next sentence is what I'm taking Charlie wants to delete. The initial ranking shall be performed and presented, blah, blah, blah. And if we take out that sentence, all that discretion is still there. That's what I'm reading.
Okay.
So all in favor of taking the sentence out? All opposed? Okay, that's out. Okay, anything else on 1? Number 2. Anything on number 2? And if I really want to get this done so we don't have to get back to it, but I appreciate that y'all might not want to do that. So, number 2, going once, going twice, gone. Number 3, Charlie.
In paragraph number 3, excuse me, I don't like I guess it's in the second sentence, I don't like the use of for minute. I think it should say that the fund will use the Office of General Counsel for its ordinary and customary legal needs. It goes on to say the fund will consult with OGC should it find there's additional and separate counsel for specific purposes. I don't think we should say for many of its ordinary and customary, they should use it, but it provides them the flexibility. If they need special counsel, then they will go do that.
Right.
I don't like the use of many.
So the sentence is okay. While the charter gives the fund the authority, blah, blah, the fund will use the Office of the Senate Counsel for its order. I think what we were trying to do was to avoid what Mr. Klossner discussed last time you weren't here about the fiduciary responsibility of the board. It's all this argument about the interrelationship of the city. It doesn't matter to me. I'm trying to, what I was trying to do with this was to avoid what I viewed as ultimately a small things to get on past it so that we could get to but you may see it differently.
To me, the sentence after that provides the fund the ability to do that. If there's something that they think they need separate counsel for, that gives them the specific ability to do so.
Okay. Is there a second to Charlie's motion to delete?
Can you restate the motion?
The motion is to delete the word many of on the third line so that the sentence would read, while the charter gives the fund the authority to employ separate counsel, the fund will use the Office of General Counsel of the city for its ordinary and customary legal needs.
Second.
Discussion.
Yeah, let me
Kat?
discuss that some. You know, I think this is one of these real areas that the pension fund feels very, protective of its counsel. And frankly, I think that the pension fund could probably use the Office of General Counsel more often. But it would seem to me that it would be better, changing that sentence, your amendment, would suggest that the pension fund was doing something wrong if it did not use the Office of General Counsel for a certain case, for handling a disability benefit or handling a determination of a benefit. And that would, I think, restrict the pension fund unnecessarily. The pension fund does need to make these decisions. I'd feel a little bit more comfortable if there was a more formal auditing provision in there of the way in which counsel is being used, more so than just conferencing. Because I think that there have been some times in the past that they've used outside counsel when they shouldn't have used outside counsel. And I think that's something that we need to encourage them to use the General Counsel's office more. What I don't want to do is I don't want to get away from our goal of coming up with a document that's going to be acceptable to the pension fund, and it's going to assist us in getting this whole big problem resolved. I understand what you're saying, Charlie. I just think it's going to cause too many fights with the pension fund.
John Wilbanks.
So are we saying that there are three categories of issues? So what of the ordinary and customary are not covered by the special funds or the special needs there? In other words, are there really two categories, or are there three categories?
Well,
The ordinary customary would be real estate matters. I know that they've just referred to the general counsel's office a dispute whether a beneficiary owes money back to the fund or not, that sort of thing. But for the real pension-related stuff, they really need, and Cindy would be the first to say they need pension counsel.
And that would not be handled by the second category of those that require special. I think that's Charles' point.
Right.
It's already covered in the second sentence, so why do we need
Yep.
So are there two categories or three categories?
There are two categories, ordinary and customary, and for specific purposes, right, that are not. What if we said this, the fund will ordinarily use the Office of General Counsel, blah, 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 for its ordinary and customary? So that, okay, I'm trying to balance this out here, so if y'all don't like that, it is not my decision.
I think the debate is, should there be a rebuttable presumption, right? The presumption is you're going to use the city.
Right.
But if you got a really good reason why it's not appropriate,
Right.
then you return
Okay.
the right, so.
Okay. All right, so that died. All in favor of Charlie's motion to delete the words "many of," raise your hand. 1, 2, 3, 4, 5. All opposed to removing it, raise your hand. 1, 2, 3, 4. 5 to 4. The chair can either vote to create or break a tie, but I guess if I voted against it, that would create a tie and it would fail. Is that right? So I'm going to vote against it, and we'll leave it. That's Parliament. That's, Cindy, am I right on that? The chair can vote to break or create a tie.
You can only vote to break a tie.
The chair should be voting in any event,
Oh.
and then it's simple math.
So what happens if it's a tie vote?
It fails.
Okay. So the chair will vote no.
Okay.
So it fails. Thank you. Okay. All right. And recognizing we've all got good reasons. This is, so. Number 4, term limits for board members. Any questions? I want to take Bob, Ted, Charlie. No, your hand was up first. Okay.
Good. Well, we're providing for 2 terms of 4 years each, and that's 8 years. And this fund board member can come back after a year off. And of course, John said that that only applies to those appointed by city council. And so that is a question, but I think those appointed by city council should be held by the same terms as those elected by the fund, selected by the fund. So at any rate, I think all of the fund trustees should be limited to 8 to 10 years of service on the board, and that there should be more turnover, and that term limits should be what it says, term limits.
So that, I'm going to take that first as a motion to delete the coming back,
Yes, to delete the coming back.
which is there a second to that?
We voted on that, right?
No, we voted on the investment committee. This is on the board. Is there a second? Surely there's a second. So you want them to be able to come back on the board, but not the investment committee?
Second.
Second. I want you to hear whether you're consistent or not. All in favor of?
Can I discuss that?
Yes, you can
Two
discuss
different
it.
things.
Yeah.
Okay. All right.
I think it is 2 different things. I mean, I think that and the concern here is, when you've got the employee elected members, these are policemen and firemen, okay? They are not, the council is going to presumably be appointing folks with investment backgrounds
They
and
have to.
financial ability. And I think that's the reason why we didn't need these people to be continuing for multiple terms. We want to get some fresh perspectives, but they're all going to be fresh perspectives from people who have a lot of sophistication and experience in these areas. It's a different matter when you're talking about employees who actually, the pension fund spends a lot of money and a lot of time educating the employee members.
I'm
on the
hearing,
pension fund.
I'm hearing two different things, because Bob, I think, was moving the term limit comeback be removed for all of them. What I hear you saying is that there should be no term limits on the members.
I think.
That's a different issue. Let's go.
But if we take it off for, well, I think you're right. I am saying that we should exempt the employee elected members from any.
Let's come back to that.
Okay.
Okay. So let's, all in favor of deleting the comeback provision on the board members, raise your hand. One.
Wait. Say that again. Deleting the comeback provision.
For all board, we'll come back and then we'll deal with whether whether council elected members should be treated
So
the
can
same.
you rephrase the question?
Should we delete the requirement that once you've served your maximum terms and been off a year, you can come back on for another 2 terms?
Should we delete it?
Should we delete that ability?
Okay.
That's the question. Everybody understand?
One more time. So we wouldn't allow anybody to come back.
That's correct. After 8 years service. All in favor of deleting that requirement, raise your hand.
For the city,
Not deleting the requirement. What would it be? Everybody. All members.
See, that's the problem is we're not sure whether it's going to apply to, if we're going to exempt the employee members, that's almost necessary as a first vote.
All right, let's set this vote aside and then talk about that. Okay. Dave?
that was my request as well, that
Okay.
maybe, I think it's a very good point, that you're dealing with a complex topic and there's benefit in having somebody that's up the learning curve, right? I think the context for that question comes, though, in the environment of whether or not, the city has effectively maintained control. I believe the city should have control, but it should have an open policy hearing the matters that are relevant for discussion. So I think the 5th member, as proposed by the mayor to be selected by city council, in my mind, drives a lot of the willingness and ability to be flexible on all the other points. And so some discussion on the 5th member as a starting point, I think would help me make a decision.
Okay. Discuss. So you think that the current proposal that the council has now passed, which has the council electing the 5th member, not the mayor?
Well, the council or the mayor, but not selected by the other 2 members, the other 4 members, but selected by the city council and or the mayor, I think is the right approach. Yeah.
And just kind of point of clarification, the council can't do that. What we can do is we can ask the legislature to pass it. So we've asked the legislature in the form of a resolution to pass that. We don't know what will happen in Tallahassee.
That's right. Bob?
Is it the committee's intent to make a recommendation here, even though John's indicated that their board would probably not support that, so that it does take a statutory change?
Yes, I think in either event, it would take a statutory change.
But it's our intent to recommend a change?
Yes.
Okay.
Either way. So the question is, I guess the basic one is, are we in favor of supporting the council's position that the council should elect the 5th trustee as contrasted with the 4 trustees selecting the 5th trustee? Do you want to put that as a motion, or do you want to put that as a motion?
So moved.
Second?
Look, we discussed that.
Yeah, let's get a second. Second by Charlie. Okay, discussion. Ted?
I've never thought that the 5th member is a big issue. I really don't. I believe that whether or not you appoint the 5th member by an election of the 4 members, or you have the person appointed by council, you still have the same fiduciary duties. It's never historically made a difference. But it seems to be this big sticking point. And I think it's a huge sticking point with the police and fire pension and the unions. And what I don't want to see, I think that in order to have our recommendations implemented, in order to go forward at this point, Bill has put in a tremendous amount of work, and he's talked to John Keane, and he's tried to get the pulse of what they're willing to accept. I think if we monkey around with issues that are so fundamental to the unions and to the pension fund at this point, we're not going to have a chance of this passing. And this is an issue that is fundamental to the unions and the pension funds. I don't think it should be, but this is their opinion. And for that reason, I don't want to sabotage our efforts by coming up with an issue in terms of who is, but by changing our recommendations on who is the fifth member.
Okay, thank you. Other discussion? Charlie?
My comment was I didn't like the addition to say that we do not support the recommendation, that either the city council or the administration reports the fifth member. The addition to the end of paragraph 4 is what I really object to, in that we're going on record saying we don't support that. Personally, I do support that, but what we're recommending here is perhaps an interim solution. Whether that gets passed or not is outside our ability to affect it. We could obviously make a recommendation for or against it. I'm not in favor of recommending against the fifth member being appointed by city council. I'm in favor of that, which means you take that last addition out.
Okay. All right, so we'll come to that in a minute. John?
Well, for a point of clarity, Tad had mentioned that he was worried everything would not be accepted if one thing was adverse to a party. Is that how this is going to work? I mean, or is this going to be something where they may decide to use some of these recommendations and not use others?
The council's got the ultimate decision on this, the mayor and council.
So as a group, then, do we need to be thinking about it philosophically as all or nothing? Or let's just make our full list of recommendations and see what sticks?
In that regard, we need to do what we think is right. There's no question about that. We need to call it as we see it. The reason it's drafted like this, though, is that in evaluating whether we have a better chance to get an overall agreement without litigation, it seemed to me that this was not as important as we once thought it was because of the powerful investment committee that we have. And that says a lot to me. So that's all I'll say on it, because y'all...
Can I offer
Yes.
another solution, perhaps? And that is, I think you're right. I think the investment committee is a powerful concept. So another way to Plan B might be, instead of having the fifth member recommended by the city council or the mayor, would be to allow the investment committee to have direct access to city council as opposed to just having access to the fund. So for some reason, the investment committee makes a recommendation, and they believe that despite their recommendations, people aren't just getting this. There's something important here that needs to be revised. So is there some kind of a footprint on a direct, I mean, well, I don't know if that's a good idea or bad idea, but it seems like giving more power to the investment committee is a solution to the problem.
Yeah.
But then you sort of confuse, well, who the heck is running this thing?
Well,
Is it
remember, the city council
or is-
has to
Right.
approve all the members of the investment committee. That's a significant power.
Right, but the investment committee's responsibility terminates with the fund
Correct.
trust, right? And
That's
so
right.
that makes the fund members important.
Right.
And,
One question is, if the city council has to approve all of the investment committee members, and the investment committee members turn over every 3 years...
They don't. They change over 9 years.
Well, they have to be reappointed after 3 years.
Right.
Could political issues then begin to play a role on the investment committee, and lack of continuity then become an issue for the investment committee?
Yeah.
Is 3 years appropriate?
Okay. Bob?
I think if we steer away from a well-constructed and time-tested format of having a board of trustees, that we just, we run the risk of having to rewrite the entire bylaws and charter and everything else. So I would not be in favor of trying to change that format.
You mean to keep it like it is?
Just to, David suggested that maybe we do something other than a 5-member board, and I just think that's a very difficult hill to climb.
All right. Charlie, you got your hand up?
Well, I'm a little confused as to what motion we're discussing.
Right.
The original motion I thought we were discussing is whether or not a member of the fund board could be reappointed after 1 year absence. I think that's the question, because there's at least 2 other questions that I think need to be discussed. I think we're getting confused as to what we're voting
We
on.
deferred that question until we resolved the 5th trustee. So we
Okay.
set that aside.
Okay.
And then
So the question on the table now is, are we going to either support the council's position, oppose the council position, or take no position? That's sort of our three options.
Or leave it, well, change it, I mean, keep it like it is, and
When you say
either.
it, you mean the red line addition to the end of the paragraph?
Yeah, we can take that out and then not take a position on the other. So let's take all in favor of taking out the last sentence, because of such reforms we recommend.
Hey, Bill, so that's the wording change to affect what? So the big answer to Charlie's question is, what are we doing?
Then, if we take that out, then we're going to vote up or down on the fifth, who elects the fifth member.
The addition to the end of the paragraph
Yeah.
says that we are against it.
The city council.
Right.
So what your question is, do we want to delete the paragraph that says we are against the council's position?
Correct. That starts, because of such reforms, the task force further recommends that it modify its request. Thus, the council would continue to blah, blah, blah.
So the motion is to delete that.
Delete all of that.
Yes.
To the end. Is there a second?
Second.
Any more discussion? All in favor? Okay, all right.
So I have, it's easier for me to follow on the marked copy. So the
Yeah.
marked copy, all of this is in blue. Are we talking about eliminating everything in blue here?
I don't have blue, but,
No, yes, it's not everything. It's the last part of blue in paragraph 4. It's not the first part in paragraph 4, it's the very last.
it starts,
chunk of paragraph.
because of such reforms.
Yeah.
To the
So
end of
we're
the
talking about
sentence. Right. Deleting that. That's the motion.
Okay, and Mr. Chairman, have I got
Yes.
have I got the floor? Okay. And so essentially, this vote is deciding whether the task force will or will not take a position on this. And by deleting it, we will not take a position. Is that correct?
No, because prior to that, we leave it as it is, because it says at the beginning, trustees of the fund appointed by the city council shall serve at the pleasure, but in any event, trustees of the fund, whether appointed by the city council or elected by police and fire members, will nevertheless serve a maximum of 2 consecutive 4 years. So the term limits would apply to everybody. That's different.
That's
But
another vote.
That's a different vote. But
Right.
this is a vote to not take a position on the fifth member.
That's it,
Well,
okay.
can,
what I'm-
Bill,
In that paragraph. In paragraph 5, we address it.
Right. Okay. Bob?
one more clarification. My understanding was if we deleted this, then we were going to have a discussion about whether we were going to make a recommendation about how the fifth board member
That's
should be
correct.
appointed.
That's what I intend.
Okay, so it's not that we don't know whether we're going to take a position on it. Right now, we're just voting to strike this.
That's correct.
Okay.
Okay. All in favor of striking it? All opposed? That's unanimous. Okay. No, Ted voted against. Okay. So that comes out. Now, let's go back to paragraph 4 as a whole, because the concept is that's embedded in it is that the fifth member is elected by well, I guess it's not. It's not. So, okay, so we could leave 4 like it is.
Right.
As amended, right.
Except for the motion to.
Except for the motion to no comeback.
No comeback.
Well, and before that, I think we were going to consider whether or not we were going to apply the term limit to the persons elected by the employees.
That's right. Okay.
And I think that is important to
All right,
determine.
let's keep yours deferred.
Yes.
So Ted would you like to make a motion?
I would move to remove the provision regarding term limits for members elected by the employees.
Is there a second?
The discussion?
Yes.
I think my willingness to support that, which I would be, is contingent upon making sure that the fifth member is controlled by the city council or the mayor.
Okay.
And I would support it. So I'd like to actually put the question for paragraph 5.
Okay, so that's a motion to table this, to postpone it until we take up paragraph 5?
Yes.
Okay, is there a second to that? All in favor? All opposed? Okay, we're going to paragraph 5, and we'll come back to paragraph 4.
Mr. Chairman, I was thinking I could sit up here so I can keep track of the motions and make sure that they come out? when
Yes,
you're done?
ma'am.
Okay.
Okay, paragraph 5, the 5th trustee shall continue to be elected by a majority vote of the other 4 trustees. Okay, is there discussion? Anybody want to move anything? David, you can remove that now if you would like. We support we think the mayor or council should elect the 5th trustee.
Right, so what meets the better sense of those who would be in favor of that proposal? That it's adopted by the mayor said the mayor should do it, the city council said the city council should do it. Is that what the mayor said that? The mayor said.
The mayor said that at one of our earlier
Yeah,
meetings.
in his presentation,
And Mayor's here. Welcome, Mayor.
He strongly recommended, as I recall.
Right, okay.
That the mayor's office appoint the 5th member. I'm supportive of that. I could also be supportive of the city council taking a direct role.
What if the mayor appointed with the approval of the council?
That's great.
Okay. I'm going to take that as your motion.
Second.
Second, any discussion? All in favor? Well, it's still got to be done by statute. That's how, right, it's got to be, and the paragraph at the end says we ask the council to take steps to amend the charter or seek legislative, but you can't do it by ourselves, right. So with that in mind, all in favor of the motion, say aye. Aye. All opposed? That's unanimous.
No, it's not.
No, excuse me, I'm voting against it, right.
Yeah, I'm voting against it.
And Greg's voting against it.
And I am.
And you're voting, so it's all of us except 3, Tad Delagle, Greg Anderson, and I voted against that. Okay?
And the motion was?
And the motion was that we recommend that the 5th trustee be appointed by the council, by the mayor with the advice and with the approval of the city council. Okay? That's
Right.
what we did.
That's correct.
Okay. All right, good. All right, now let's go back to number 4, and I'm trying to rush this a little bit so we can take a break before we hear the others. Back to number 4 now. The first question is, should the term limits apply to the trustees elected by the membership, meaning the police and fire? And that's, David brought that up. Is there a motion to not apply term limits to trustees elected by the fire and police members? Is there a motion to do that? Ted is doing that. Bill is seconding it. Any discussion?
Yeah, repeat the.
We're saying that the persons elected by the 2 trustees, one elected by the police members of the fund, the other elected by the fire members of the fund, they will not be subject to term limits. That's the motion.
May I offer a comment?
Sure.
If we could make the motion so long as the 5th member is approved, then would the committee otherwise support? I would
Okay.
endorse that.
We'll take that as a, so long as
It's
the,
not a friendly amendment. I'm just, you've already made that recommendation in number 5. So this is, I don't support that. So I think that we just make it so that the employees can reelect their members.
Charlie?
I think Mr. Keene did a good job of explaining why that's important to the membership. You know, that is their election of who they want to represent them. And I don't see the need for us to try to change that. So I'll support the motion that the term limits not apply to those members elected by the police and fire.
Okay. That's only 2. That's right.
Those 2.
Right. All right. Were you going to say something? Nobody? Oh, Greg?
And I'm not trying to throw cold water on this, but I don't really understand the reasoning why you would apply different standards to different trustees. To me, they're all trustees. Their duties and responsibilities are the same. Why would you have one set of standards different than another set of standards? So I can't support it just for the reason that I think we're trying to, A, simplify it, and B, have consistent standards.
Okay, thank you.
And I would agree with Greg that since it seems unreasonable to limit the terms of the fire and police appointees, electees, that we should, I take it back, with retreat from that position because they should all be treated alike.
So you're against the motion?
I'm against the motion that I originally proposed.
That's all right. You qualified to be a politician. All right, are y'all ready to vote? Let's don't say everything we've said before.
No, it just simply in response to that question, I mean, we're going to presume that people with a lot of background and experience in this area are appointed by the council, whereas we're dealing with folks, with the police and fire members who are not necessarily going to have that specific experience, and that's the reason we may need some more continuity for the employee members.
Yeah, no.
Okay, well, I mean, we can get into a great debate here, but Mr. Chairman?
Yep.
And I'll stop, promise. But isn't that then more example of the reason why the members need to be careful who they elect?
Oh, yeah, sure.
But
Okay, ready to vote? All in favor of the motion?
We're not considering the 1 year. and
That's still out. Okay, all in favor of excluding the trustees elected by the police and fire from the term limits requirement, raise your hand. 1, 2, 3, 4, 5, 6. All opposed?
Well, who's in favor?
Wait a minute,
I would,
oh, you are opposed, right. Okay, let's go back. All in favor of excluding the trustees elected by the police and fire from the term limits, raise your hand. 1, 2, 3, 4, 5, 6, 7.
But who's in favor of term limits on any trustees?
that'll be next.
Okay.
Wasn't that the
No.
answer?
Let's don't confuse it any more than it is. All opposed to excluding those trustees, raise your hand. All in favor of excluding?
Exclude them or not is
I
relevant.
thought that's what we just voted on. Cindy, is that what?
I think it passed. You had 7, didn't you get 7?
All right, so they're
Yeah.
7 to 5.
7, they're excluded from the term limits.
That's
Right, okay. Y'all got that, okay. 7 to 5. Okay, now, let's go to Bob's motion to take away the comeback provision. We'll come back to you in a minute, John. Let's get this stuff done. We're voting now on whether to require, that you can't come back once your term limits expire.
For the appointed members.
For the appointed members. Bob?
Bill, just a point. If city council has a right to recall their members at any point in time, and we just excluded term limits from employee elected, then I don't know what sense that provision
Whether we should have
makes.
term limits at all?
Yeah, I don't know whether we should have term limits or exempt people from term limits. It appears to me that they serve at the pleasure of the council, and that's all we need to know
so
about
that's
that.
Right, so I'm going to take that as a motion to amend to delete the term limit requirements for all the board members, given the fact that the council can recall anybody at any time.
Right, I second that.
Second, that's a motion to amend on the amendment to delete the term limits requirements for all trustees. All in favor, say, raise your hand. 1, 2, that's
There's no
No-
re-election? You just got, you're going to.
no term limits, because the council can recall.
But three.
But the council can recall a trustee at any time,
And
That's
so
not likely.
can the police and fire.
and so can the police and fire.
Trustees serve at the will
Right.
of their constituents.
Right. All right, let's go back so everybody understands it. All in favor of deleting all of the term limits requirements, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Okay, so term limits are out.
The principle being all members are treated.
All treated are treated the same. Okay, all right. So then we don't need to consider Bob's motion anymore. So let's go on now. We've dealt with number 5.
So did we change anything?
We deleted the whole paragraph, is what we
I
did.
mean, from the current
Yeah,
government.
we didn't change any of the governance of the board. Okay. We had, on number 5, we have now changed that, y'all recall, to the mayor with the approval of the council. Number 6, actuarial standards. Charlie?
Again, just only one word in there bothers me. This is a recommendation. and I understand going to 120 days, but the fund shall endeavor to complete, I think we should say the fund shall complete, deliver such analysis no later than 120 days.
Here's the reason that that's in there. On some occasions, the city has not provided the information that it is needed to the fund so that the fund could complete its work.
I understand.
But
Our
you think the
recommendation-
standard should be they should do it?
I think our recommendation should be it's done in 120 days. If the city causes a problem, there needs to be a discussion about that.
All right. So your motion is to delete the words endeavor to
Right.
in 1, 2, 3, 4, 5, 6, 7, 8 lines down.
Yes.
Second to that motion.
Second.
All in favor?
Aye.
All opposed? That's a unanimous
And-
vote.
And I'm not sure we should dictate the 7% discount rate for a period of any time, because circumstances change. I'm not sure that should be in governance whatsoever, is declaring the discount rate, whatever it may be. The assumed annual actuarial return, rate of return will remain at 7%. I'm not sure this should be in governance at all. That's what you have the investment committee for.
Well, I thought we did that because that's going to play into what our unfunded liability discussions are and the pension design.
I think you make a great point. I think it's designed to sort of bring resolution in the short term, so where do we come out on this? And then secondly, it's modified by, or you can...
Unless otherwise agreed or as
the city
otherwise
and the
required.
fund. So if the investment committee were to say, look, this is just not appropriate, and here's the reason why, it would be a...
Charlie?
I'm in favor of the 7% staying in there because it relates to the 2014 agreement, which is the earlier of 2024 or the time at which 80% funded status is achieved. So all we're trying to do is put a standard in there until we get to 80%, and then that goes away, and then that will be discussed at that point.
Okay.
But if the 7% discount rate doesn't get us to 80%, then what? We're perpetually locked at.
We're perpetually locked at 7%.
That doesn't make any financial sense.
Is there a second to John's motion? Dies for lack of a second. Any other questions on the section?
Yes.
Greg?
I think Charlie brought up a good point, and I'm a little confused by the 2014 agreement. Is it defined?
Yes, that's over in paragraph 9, fourth line of paragraph 9. That's the existing 30-year agreement as modified by a new agreement or an amendment to that agreement.
Okay.
To incorporate all this.
Okay, thank you.
Right. John Trichter had a point. Okay?
Actuary's coming up.
Thanks,
Gosh,
Mr.
it
Chairman.
takes
Good morning,
bodyguards?
everybody. Hi, it's nice to see everybody again. I think we all wanted to weigh in on this just a bit. I think the intention of putting the 7% in this context were good, but I think there's an unintended consequence. I just wanted to give you context. I think we all did, right? One is that, or I think the key point is that the 7% discount rate or rate of return is an actuarial determination. It's supposed to be made by the fund, its board, its trustees, with input from the investment committee, and in conjunction with the investment consultants, and deeply tied into asset allocations. Many of these things are fluid, right? The latter couple of points are fluid, and so they change over time. And so to put stipulate that a rate of return, to stipulate it or put it in a contract, in a contractual sort of framework, strikes us, I think, as potentially the wrong way to approach it. And so that's the point I wanted the committee to consider. You guys want to add something?
My only suggestion was after agreed to by the city and the fund, based on sound actuarial practice. I don't think people are going to do it, but I'm nervous that if sometime push comes to shove, the city and the fund could agree to raise the rate in return for benefit improvements. So I just think you need something in there, sound actuarial practice.
So you're okay with leaving the 7%, but adding after, unless otherwise agreed by the city and fund, based on sound actuarial practice?
Something to that language that, it's based on actuarial practice.
Right, it's not political. Right. David?
Yeah, I mean, this is an actuarial determination. It should either be made by the funds, and the fund board based on investment council or advisory council input and the actuary input, or, if you want to enshrine in the contract, at least, make sure that any changes are based on sound actuarial practice.
I think John's motion failed for lack of a second, but I'm going to would someone like to make the motion that we add the words based on sound actuarial practice after the word fund in the third line?
Well, I think we need to be careful here. Are we wanting this to go into the governance of the pension trustees? And if we are, do we want to lock them into an actuarial rate? I think what we're hearing, and I want to get confirmation, is that could be very dangerous.
That's what Jonathan said.
And I understand from Mr. DeZubi that his intention is to give the rate of 7% as a ceiling, but not as a floor, in the event that, or is that not what you're saying?
That's not what I'm saying. I'm just
Right.
saying that down in item C, the actuary is going to be doing experience studies, which is going to look at, as we're talking earlier on allocation, asset allocation, and come up with, under actuarial standards, a range for what the rate of return is going to be. And somehow I just want to see that tied back into after the actuary and the plan.
Okay.
It's not a floor or a ceiling.
Bob Miller.
Bill, in line with Charlie's earlier comment about prescriptives, I would like to move that we strike the 7% and that we add the language about sound actuarial assumptions. And seems to me, we've had 18% return rates and we've had 1% return rates, and that the fund and the actuaries need to have the ability to move that back and forth to reflect what's going on in the economy.
So your motion is to say the assumed annual actual rate of return will be based on sound actuarial practice through the term of the 2014 agreement, unless otherwise agreed by the city and fund, also based on sound actuarial practice.
Yeah.
John, you want to second that?
Well, I would, but we're basically just doubling down on what the statutes and the law prescribes.
Well, I know that, but are you seconding it or not?
Yes.
Okay. So we have an amendment to take out the 7% and tie that to sound actuarial practice. Charlie?
I'm not in favor of that change. And the reasons are severalfold. Probably the most important, we've been trying to avoid finger pointing here, but I think it's been fairly agreed to that by using 8.25%, 8.5%, 8.75% assumed return is one of the reasons it became unachievable, and particularly in the context of the last 10 or 12 years. And had that been moved down sooner, the problem would have been more apparent sooner, and it perhaps could have been addressed in a much easier fashion than it's being addressed today. So I would agree that it would be a cap, not a floor, but I would be very concerned about eliminating the 7%, because it's only limited, it's only being used here, if you look at the term of the 2014 agreement. It's limited to the earlier of 2024, or the time at which we achieve 80% funding. So it provides a governor, if you will, on the ability of the fund to change the assumed return, which has an extraordinary impact upon the unfunded liability calculation. And one of the things we're trying to achieve is much better funding to make sure that our public safety employees get the benefits that they thought they're going to get.
Okay.
I'm definitely against eliminating 7%.
Okay. Other discussion? Bob?
I withdraw my motion.
All right. John, you seconded it. We're going to have to vote on it because I don't think John's going to withdraw his second. Are you going to withdraw your second?
I like what Charlie said.
All right. So the motion is withdrawn. So now the motion is to add the words based on sound actuarial practices after the word fund on the third line. Is there a motion? There is a motion. All in favor of that, say aye. Aye. All opposed? Thank you. I never want to run for city council. All right. We've already taken that endeavor. Anything else on paragraph 6? Paragraph 7. We've heard John Keene's remarks. This basically comes out of the mediated settlement agreement. Any motion to change anything on that? Seeing none. Article 8, Section 8.
I got a question on 8.
8, yes, Charlie?
I think Mr. Keene's statements on that were pretty much on point. It seems to me the fund administrator is a city employee. Without getting into the other arguments about that, why wouldn't the fund administrator be a participant in the general employee pension fund? That person should not be held out separately from every other employee of the city.
So you're taking out the defined contribution.
I'm saying that he should be, that person, I should say he, that person should be a participant in the general employee pension plan, just like every other non-safety employee of the city.
And I think I can respond to that, which is all right with me, and I think that would be all right with John, but when John first applied to be in the general employees pension plan, they said he wasn't an employee of the city. And so he's the only person employed by the city of Jacksonville that was not, or an agency that was not eligible. Cindy?
No, I think whatever the employee said, Mr. Keene was a previous employee of the city. You can't retire and go back into the pension fund at the level at which they sought to have them. And there were all kinds of different issues on FRS or city or senior management plan. So I think cleaning it up in the future is fine. Putting him in the GEPP is legal and there wouldn't be a legal obstacle should the task force seek to do it.
Let me ask a question on that. That was a good issue, Cindy. If the person who is selected is a retired member of the police and fire pension, would that prevent the individual from going into the general employees pension fund?
It may if they adopt the qualifications. Aside from the qualifications, if they were a retired member, then they couldn't be in the, they would still be in the GEPP, not in the police and fire pension fund.
Because I guess that was the issue with John King. He was a retired member of the police and fire fund. And perhaps that was...
It's probably best not to
let John
debate
answer
that right now. I think the issue going forward is could somebody legally be in the GEPP as the city fund administrator? And the answer to that is yes.
Is yes, okay.
Yes.
John, briefly, please.
We agree with the general counsel, and what it takes is an amendment to Chapter 120, which would then add the administrator of the police and fire as one of the agencies that can participate in the fund. Currently, in addition to the general city employees, they got the housing authority, of course, they got the JEA, and there's one other agency then. You just simply say, or administrator of the police and fire, amending 120, and that would make that individual then eligible.
So our recommendation should be that 120, the ordinance code be amended, or the ordinance code be amended to provide that the administrator would be in the GPP.
Mr. Chairman, I wouldn't worry about the method by which it is. I would just identify that you'd want them in the GEPP.
Okay. All right, so
and that'll simplify the document.
Okay. So let's get that. Charlie's made a motion. Somebody made a motion. Who did that? Charlie.
I think I did.
And there was a second somewhere?
I'll second.
Okay. Gwen seconded. Greg?
Got discussion?
Yes.
Okay. Mr. Chairman, I just wanted to know so the only risk with that is that the person making the investment decisions is also benefiting from those investment decisions?
No, that's the GPP.
Okay, so it's
Right.
not...
It's not the police and fire.
Okay, fine,
Right.
fine, thank you.
Any further discussion? So we'll change that to go into the GPP. All right. All in favor, say aye. Aye. All opposed, that's unanimous. Okay, status of the 30-year agreement. Any questions about that?
I thought we decided to do it semi-annual because of the cost, so we changed it back to quarterly.
John felt that quarterly was important because semi-annually you got too far out. And he views it, if there's nothing wrong, he's going to send a letter to the judge saying nothing's wrong. He felt strongly about the quarterly. Any further discussion? All in favor of paragraph 9, say aye. Aye. All opposed, unanimous. Number 10, return to collective bargaining. This was originally that it was at the end of the agreement, but now given Judge Wallace's decision, it starts now. All in favor of 10?
We have to have 10 in here.
Yeah, I think that's important because it clarifies about the collective, why we're not doing something. Because our recommendations are going to collective bargaining. Okay, that's unanimous on 10. 11, consultation among parties. I would think everybody would agree with that. 12, expression by charter and ordinance. Everybody's okay on that. 13, you've heard the discussion on that. That's okay with the city. Any discussion on that? So that's unanimous. So on the investment authority, I'd propose to defer that until we can get that more looked at, but that will come back. So as I think y'all have approved the governance proposals as amended, and get it working with John and Cindy and get that back out to you. So let's take a break. Before we take the break, I had asked, just so y'all know, we're going to have a presentation by Mr. Hightower and Mr. McElroy coming back, and then by David Drain. I did ask Randy Wise, who's the union rep for the fire, and I asked Mr. Amos, who's the rep of the, Steve Amos, who's the rep of the Fraternal Order of Police, if they would like to address us as to what they heard about the mayor's proposal and anything else. They both had said they appreciated the opportunity, but it was their legal position that they were not subject to collective bargaining, number one, or they were subject to it, but they could waive it. They had waived it. They have a legal position on the lawsuit. They have filed a motion for rehearing, which the city has joined in. And they just pointed out that they were saddened, both, and they gave me permission to say this, that they were both saddened by Judge Wallace's order in the sense that it removed our ability to deal with the pension design now. And I share that sadness, but unless that order is modified or reversed, we can't do that. So, Steve, I thank you for your willingness to come, but we understand your legal position. So, now let's take a break of, it's now 11 o'clock, let's come back at 10 after 11. Thank y'all for your patience. All right, let's come back to order. We're now going to turn David Drain. We have his slides in our packets, so we'll come back to David. Right now, we'd like to invite to the podium, not the table, but to the podium, Mr. Hightower and Mr. McElroy. And you need to speak into the microphone. Now, I would like to say neither of y'all were here when we began this morning. I had a few remarks about this committee is trying to stay above all the politics and everything. We're trying to do the right thing as we see it. Now, people may disagree with how we see it, but we're trying to do it that way. And the Sunshine Law prevents us from having private brainstorming sessions. So we have treated every idea as on the table, and we have not shot messengers, nor have we attributed any motives one way or the other to anybody that's made a proposal. So the mayor made his proposal last week. We've taken it for what it's worth. We don't have an opinion about it yet. But we, in the spirit of what the Sunshine Law requires, that's on the table. So we'd ask both of y'all the same way. We would love to, we do want to hear what y'all have to say. But it's in the context of this is a city. We're all trying to work together and collaborate with each other, and nobody has any bad ideas because the Sunshine Law prevents us from vetting bad ideas except in public. So with that, Paul or Mike, I don't know who's going to start. We welcome Paul McElroy, who I've known a long time, and very capable president, CEO. I don't guess you're the president, but you're the CEO of the Jacksonville Electric Authority. We're glad you're here. Thank you, Paul.
Chairman Shai, thank you very much, and thank you for repeating those opening remarks, and that clearly is our intent here today, is to share information. It's a work in progress in terms of the dialogue, as the mayor pointed out, and I think that when we go through and share some facts and information with you, I want to just at least point out we need to somewhat bifurcate the fact that JEA has its own pension obligation issues. The unfunded liability is about $500 billion, and we're waiting to move forward with that, as we have with our St. Johns River Power Park defined pension plan. And we went through that process over the last several years and have in fact moved to a direct cash contribution plan for those 300 employees that are governed by that. So we're here to help. I think the other issue in terms of a couple of housekeeping ideas, points, we characterize the issue of 40 million really more like 560 million. I mean, it's a long-term deal. It's a big, big number for us. And then finally, yesterday, and all respect to this task force and the committee members, we had a long-standing agreement with the council to meet quarterly and give them an update on the matters and affairs of JEA. And that's what we did yesterday, and we had some dialogue on this, so it wasn't to jump out and jump ahead of the committee, so thank you. I want to talk about 3 or 4 points. One, a little background or context. There are 4 key financial areas or drivers. Give an overview on total government transfers, share with you an independent assessment, address several questions that have been raised over the last 10 days or so in the public domain, and then answer any questions the committee might have.
Thank you.
First and foremost, the utility is somewhat under siege with respect to unit sales. Our unit sales for the since the Great Recession are down from the peak which occurred prior to the Great Recession in about 2006 and 7. So we are down 10%. Yes, sir. These are units of electricity delivered, gallons of water delivered to our customers. So since the Great Recession began, we are down 10% in electricity, and so we deliver a unit, and then a multiplier effect is how we drive our revenue. So in a sense, we've made up for that shortfall through expense reductions, cuts, and other activities in the utility. This is not a phenomenon that's unique to JEA or Jacksonville or Florida or the Southeast. This is a national phenomenon going on. And so the good days of, as the chart illustrates, 2 to 3% historic growth are well behind us, and as we look forward, we're looking at basically flat growth in the utility business, both on the electric side and the water side as we go forward. We built up a considerable amount of debt on our balance sheet. I think a number of you might be aware of that. We had a tremendous building effort and a rebuilding effort of both the water sewer system and the electric system in the period of about 98 to 2008. In essence, we did a Better Jacksonville plan in the electric business and a Better Jacksonville plan in the water sewer business, $2 billion each. And that debt built up without any price adjustments. In the period 2006 through 12, we adjusted our pricing, but we still are saddled with extremely high debt loads. And what the chart illustrates there is the green line is really the metric that we look at in terms of what the market is for similarly sized and typical utilities. So we are well above the benchmark in terms of our overall debt load. That said, we have an aggressive plan in place that we have been executing now for the last 3 or 4 years to pay off on the electric side $250 million a year in debt, and then hold flat the water sewer system debt and pay off about $25 million. We've reduced that debt by $100 million over the last 3 or 4 years. So in terms of cash flows, it's key to stay on track here and getting this debt down more towards industry standards. We have facing us at the utility a considerable onslaught of regulatory issues affecting our business, both and then primarily the big dollars are in the electric business. We are looking now in the 2 to 10 year time frame of approximately $1 billion in environmental mandates or regulations that have to be absorbed into the utility system. The primary driver here is CO2, and really the elimination of CO2 in our electric generation production using solid fuel. So we will have to transition. Along with that, there are 4 or 5 other major rules coming from the EPA over the next 2 to 5 years for implementation, all focused on our solid fuel fleet, which is about half of our generating capability. We think the number is somewhere about $1 billion. It could go a little north of there. On the water supply, we have a $100 million question, a risk ahead of us in terms of the water management district's recent ideas regarding the regional water planning supply that they're putting forward. It's a 5-year process, and they have teed up for our community about $100 million in projects for long-term water supply planning. We think as we tie back to the fact that our sales are down 33%, we're not going to rush and support building $100 million of additional capacity when we're not even coming close to what has been allocated to us. But that's a larger issue and may get to a state level issue we'll have to be cognizant of in terms of our risk. Revenue growth I pointed to. Revenue growth is a thing of the past. Our customers have adopted efficiency standards, lighting, air conditioning. Every appliance in the house is multiple times more efficient than it was before. This happens on both sides, the residential and the commercial side. The lighting fixtures now, and we went incandescent 5 years ago. Everybody went to the CFLs. We're on to LEDs now. That's an 80% reduction in electric usage. So while we may see 6,000 to 8,000 new connections, we got 400,000 people out there that are driving their efficiency down. And so we've got to manage through that, and one way is going to be adjusting our cost profile. Pensions, I mentioned, we have a $445 million unfunded pension liability. We contribute $38 million a year on an annual basis from just the JEA. The 8% is in addition to that from the employees. It's 28% of salary. Fuel is always a risk to us. In fact, the fuel markets in terms of natural gas, we had a good run, but in the last 30 days, the annual cost of fuel has gone up $50 million. And we've got reserves to support that, so that's not a big issue for our customers, but we manage through that process. Critical infrastructure compliance. Yesterday, a small municipal out in California was fined by FERC, Federal Energy Regulatory Commission, $12 million for an outage that they were part of. And so this whole new regulatory compliance regime in the electric system, we've got to be very cautious of and invest in and make sure that we're ahead of the curve. And then ultimately now, assessing and looking at the thought of another $40 million in terms of contribution. I think with all of that, that sort of sounds a little dim, but I want to thank our customers. I want to thank the community for recognizing all the hard work that the men and women at JEA have done in improving our customer service, our service delivery, and our customer satisfaction. On page 6, the J.D. Power recently, Wave 2 in 2014, recognized a consistent, again, improvement in JEA service delivery and ranking among 130 national electric utilities. 18 months ago, JEA was in the bottom 5 of 121. This fourth quartile, we're up to 58 out of 136. They've added some. In many of the attributes on the right side of the slide there, we can see that our service, our customers tell us that we are in the top quartile, the best of the best in terms of customer service, quality, reliability, billing and payment, communication. Where we fall down is price. And so we're a little concerned. A lot of utilities in that fact that unit sales are going down have pushed the price lever to try to make up for the revenue shortfall, lower unit sales. And we have been able to push that off and plan to keep pushing that off as far as possible. And I think that's supportive of what our customers and our community are sharing with us. Price is still an issue. So in summary, in the background, sales have fallen from pre-recession levels and will continue to remain flat. We're down 10% in the electric, 23% in water. Our margins are going to shrink because we're just not going to see the growth as we go forward. We're flat sales to declining sales. We've got a debt reduction plan that we have to keep in place. It's critical to keep in place to get our debt down, to be flexible for future events and service to the community. Environmental compliance is just a complete uncertainty and unknown in terms of the absolute dollar amount and the timing of that. Our unfunded liability is first and foremost from the JEA perspective to really look at that $445 million and how we address that, similar to the way we've addressed it with our St. Johns River Power Park pension, and price is still an issue for our customers.
Mr. Chairman, I'm going to try to move into this like jumping rope, not to do that, but on this slide, I'd like to go ahead and address it now. From the chairman's perspective, we just took every one of we have 4 new members of the JEA.
Would you talk into the microphone? Because
I'm sorry. We just came back from Washington in our early December where we met with the 3 rating agencies, and you'll see a slide up there later. This slide is very important in the discussions from the board's fiduciary responsibility. Each one of those bullets are issues that the 3 rating agencies have with us every time we go up to Wall Street. And they grade us and rate us at the end on, one, how we're addressing this, and what is our strategy going forward. So in context, as we go into the rating agency and as the CEO addresses where we're going to be going in our strategic plan for the next 5 years, it is really important that these are bullet points become, in essence, points that the three rating agencies ask us, one, how we're doing, how we've done in the past year, what we're going to be doing next year, and what is our strategy in those. So just to put that in context so that we understand it, and again, I apologize.
Thank you, Mike. On the unfunded liability, is that to the GEPP? Is that your share of the GEPP? Or is that, y'all don't have a separate plan?
We do not have a separate, it's our portion of the general employees pension plan, which we're obligated to participate in under charter.
Sure, I understand. Just want to clarify that. Okay. Please continue.
I'd like to turn to, so that's the context of the challenges of the utility, the big strategic issues, and really the call on revenue as we go forward. I want to just talk in terms of government transfers, total government transfers for a moment. The chart illustrates to the left, the pie chart, this coming year, there'll be government transfers is defined as the contribution, the calculation of, some call it a dividend, the franchise fee and the public service tax. But we look at it as funds collected from JEA customers and remitted essentially to the city for the general fund. It's 22% of the general fund for $233 million this year. In calculating it, it's roughly anywhere from 9 to 11%, depending upon the calculation you go through. And in a moment, we'll see it's a significant portion when we look to benchmark against other similarly rated utilities. In the last number of years, the bar chart here indicates that the last number of years, we've had a significant increase. In 2007 to 2012, really, 2013, we've seen a $77 million increase in the amount collected from JEA customers and remitted to the city to the general fund, or a 51% increase. Historically, and I would point out, historically, going forward now, we don't see sales growth and we don't have price increases planned, so that's going to level out in terms of the level of growth, and we're already tied in contractually to a minimum payment of $2.5 million a year through 2016. So, but in essence, there's been significant growth, and we'll talk a little bit more about this on this slide. When we entered into the current agreement that governs the amount of the transfer from the JEA and JEA customers to the city for general government purposes, we were on that nice trend line of 2 to 3% growth in revenue back in 2008. And so when we negotiated, we agreed to a $2.5 million a year minimum increase just to stabilize the city's budget process. And because historically, although the average would be 2 to 3%, it might be 4, it might be 1, and we thought we'd achieve this line. As I indicated, our sales have fallen 10% and continue to fall. And so if we look at 2014, and if we do the calculation on a revenue basis or a unit sale basis, we would be paying $85 million, and this coming year we're going to pay close to $110 million. So there's about a $25 million premium embedded in the agreement right now that we're absorbing again through cost reduction, expense reduction, and allocation of other financial measures.
And Mr. Chairman, on that, as the CEO mentioned in the slide 2-3 back, if you will look at 2015, in June of 2015 is where the EPA, we have to come into compliance on the CO2. So when you look at that whatever what we are forced to do, not negotiated, will happen in June of 2015. That is not on that chart at this point.
And the agreement itself, in terms of governing this transfer, has got a long history. We're about 35 years of 5-year agreements. This last one's an 8-year agreement that always got to run to their natural conclusion. This agreement has a 5-year opener in terms of the percentage amount, but the minimum payment's locked in for the 8-year run. So in looking at government transfers, again, defining that as to what our customers pay, because that's what our customers see, that's what our customers compare us to in their price shopping, and certainly that's what our commercial customers point out to us very directly in terms of our price versus the rest of the state, the rest of the region, and the rest of the country in terms of electricity costs. So we look at the total contribution, franchise, and public service tax. Again, it's governed by a charter and includes the minimum increase, $233 million, 22% of the budget. Ad valorem taxes are 46%. So it's a big component of the general fund. The 6-year period, we've increased $77 million, 52%. $2.5 million per year the next couple years, and a $25 million premium over what the revenue stream would support. Third-party assessments on an annual basis. We meet a very in-depth review with the rating agencies. We do not let the rating agencies drive our business, okay? But they certainly are a very important factor in us going to market and managing through our $5.5 billion debt portfolio. We are in the market probably every 60 days over the last number of years with refunding opportunities. We are not issuing new debt. We have not issued new debt for the last 2 years. Our plans call for us not to issue new debt for the next 3, 4, 5 years. So we're out of the market there, but we're very active in terms of refunding and savings. And in fact, last year we saved $33 million. Last week we saved $33 million in the market. So after that review, we issued several reports, and I'll point to the first one in terms of Fitch. And this is an assessment in terms of just where we are with the contribution. The contribution and the combination of the two figures accounted for about 11% in their calculation of operating revenue. They look at that to be about double what the typical utility of our size and scale would be, and indicate that any meaningful escalation beyond 2016 would result in mounting pressures to address the city's large unfunded liability would be viewed negatively. And so, that's the other two agencies comment in terms of it being substantial and significant. So we certainly out there as signposts for us to be aware of.
Mr. Chairman, to put that in context, and one of the reasons why the rating agencies, which we found in our discussions with them, and I don't think this comes as the Jacksonville pension issue is not unique to Jacksonville. It is throughout this country, almost every municipality and states as a whole. So when you see these comments by the rating agency, they are being looked at from just about every quarter of the country. So pension issues have now gotten to 3 rating agencies' attention. These comments are not specific to Jacksonville, but it is very specific because of the level of the contribution. And as I've said, they also are the same folks who are providing or evaluating the rating agency for other communities as well as states as a whole.
And then I'll wrap up fairly quickly. There were 3 or so questions that were raised in the public domain, focused on our gross revenue, but more importantly, operating income, $400 million last year. And on a standalone basis, that sounds like a large number. It was a little less than that. It's 389. That's not the point. But out of that $389 million, we were required to pay $234 million in debt service, principal and interest. We also transferred out of that $400 million, $106 million to the city, and that left $49 million to reinvest back into the system, and the system is $6 billion in assets. We were dinged this year in that our reinvestment rate is below depreciation. We think we're in a good spot in terms of our capital cycle and can support that, but the recognition is that our capital funding is, at this point in the cycle, just a little bit lower than where we normally would be in terms of an assessment. Next, we had $340 million in cash on hand, and that's actually 341. And that's just a measure of pure prudent financial measure, making sure that we have cash balances to deal with fuel rate spikes. It's 110 days in the water business, 125 in the electric. We benchmark against our peers. The agencies want to see 150 to 250. We shore that up with a letter of credit that we can call on should we get. So we get through that. The city thinks that's a good thing too, and we respect that and recognize that and compliment that in terms of making sure that there are reserves there to support their $2.5 billion in debt as well. And then finally, and this one's mine, we paid incentive compensation. Our team is given specific goals at the beginning of the year. If they achieve those goals, we make a payout. This year, the team achieved $32 million in expense reductions. That was part of the component of $2 million. So a 16-to-1 payout we think is reasonable, and it's not a lot of money on an individual basis, but it allows our team to focus. And in these times with declining sales and all the other challenges we have, we think that's appropriate.
Mr. Chairman, and on this slide here, this was, when you say JEA, I want to put this in context. This decision was made by the 7 members of the board. And this really comes back to, if you looked at declining sales, the things as we saw the risks coming at us, this was really an incentive that we said to our employees, we see this is coming, we're going to need your help. The only way we can save the money, we are labor intensive. We have a unique group of very skilled employees and some extraordinary leadership there. And this was from the board's perspective of we've got to begin to find, call it changing the couch, whatever it is. But part of that strategic plan, it is not going to be the board that's going to find the extra money. It's not going to be the leadership. It is the labor force. Now, and when we put that out there, they did it. And one of the things is, if you go back, is on that the slide before that where it talks about that we really have not met the standards, candidly, in the industry about cash on hand. One of the reasons that, I'm not going to use, not a lawyer and I'm probably going to get in trouble with Wall Street, they looked at that and asked that question. One of the things, though, that why they said we're not at standards is they said, but you, for the last 2 or 3 years, $250 million a year, you're reducing debt. And that is a good thing. So as we're looking at sales, looking at EPA, and realizing you can squeeze so much, we came up with the incentive plan to our employees. They know about this. That was the reason the board made the decision to have an incentive plan so that we could become efficient and continue to find efficiencies.
Great. Questions? Or do you want anything else, Paul?
That's it. That's it, Mr. Chairman. Thank you very much.
Thank you all. We just commend the JA for lots of reasons. They're out there real quick when there's a storm. Just in lots of ways, customer satisfaction is great.
Yeah, Mr. Chairman, on that issue, again, in the public domain, you probably heard last night and this morning, as we speak, there are more than a dozen trucks, a number of employees who are in Savannah at this time because of the ice storm which is being confronted. And that is sort of a reciprocal type of thing.
Are the residents of Savannah contributing to our pension plan?
Yes. Well, if we ever have a bad situation, they're coming down here to help us. We appreciate the opportunity.
Thank you. Questions? Charlie.
More of a comment than anything. I'm reasonably familiar with JA operations, having served on the board for a short period of time. It's a very complex and far-reaching organization, and this was an excellent summary presentation, but I'm not sure this task force is really equipped with the necessary information to come to any conclusions as to what could or could not be done. I know the administration is speaking with the JA about that. There's just so many aspects of this thing. The JA doesn't pay income taxes, et cetera. So, if you compare it to a profit-making entity, et cetera, so it's a very complex and far-reaching organization, and it would be difficult for us to be able to analyze this and come up with a rational recommendation with the administration and the JA board and executives working on that.
Yep. Thank you.
Yeah, and on that, in disclosure, again, in the public domain, reacting to public domain, and the chairman, who is part of that public domain, you heard my comment for the number. We are attempting to put into a process. Charlie will tell you this. The JEA's first fiduciary responsibilities are, as this chairman sees it, first to the ratepayers, and secondly, because what we do with our ratepayers, the rating agencies. So we have 2 major stakeholders. On the issue of where we are, let me tell you the process, is that we, as I said yesterday in the paper, we are open to anyone that has a proposal. But the process has been for as long, and I've been on the board now for 14 and a half years. been watching it for a number of other years. There's a process, whether it's the city or someone else. Bring a proposal to us in a formal proposal. At that point, the board will then determine, we'll look at it. We, at that point, would now, given a couple of our former chairs who created it, we have an audit and finance committee. That proposal, then, the chairman will look at it, talk with our CEO, and determine, in most cases, when someone is asking for something, we send that proposal to the audit and finance committee, because they are the ones who basically the board looks to, which is made up of board members, in this case it's 4 board members, who have financial backgrounds, is at that point they will begin to do, quote, the due diligence. And then at that point, the CEO and his staff begin to look at. Given what the due diligence is, they will then come back to the board. Given what they have done as the Finance and Audit Committee, we'll bring it back to the full board. At that point, the board will make a decision in looking at it. So that's really how the process is. Again, you know, these are energized times. There's a lot of emotion. There is no silver bullet. I think you all have found this out. I think the people sitting in this room represent that. There is no silver bullet to this. But in this case, and this is not meant to be critical or anything, the JEA has a process and a procedure of which we approach anyone who comes to us, whoever it is, about helping them. It's not, and I don't mean this in the wrong way, when you read the charter, our fiduciary responsibility is first to the ratepayer. Present us with a proposal, and then we put in motion the process to do the due diligence, and we will do that, and we look forward to it. And there have been other folks who have come to us, charitable and some other reasons, and we have a process. It's not ours, not mine. It's the way we do it, and that's what we attempt to do. And candidly, the rating agencies understand that we are. And that
well, we understand, and I knew that they had some preliminary conversations, and those will go on. And as we understand it from your comments, that there's a willingness to discuss, but it's certainly, finality is probably very unlikely before we go home from our work. But it's just another thing on the table.
Yes, sir.
The conversations. So
thank you.
Thank you all very much. Any other questions, comments? Thank you. Oh, let me just, I had asked Joey Gravey the amount, because as I understand it, is it the public service tax is a 3% rate. The city has a cap on that of 6%. So as another potential revenue source, taking into account all that you've just said, is the possibility of raising that from 3 to 6%, and that's about a $28 million. Each percent is worth about $28 million. Is that right, Joey?
So the public service tax is 10%, and that's separate. The franchise fee.
Maybe it's the franchise. It's the franchise fee.
Yeah.
There's a 3%, 6%. Not that we're deciding anything about it, but it's another source of potential revenue.
Yeah.
Taking into account all that you have said, there is a possibility of a $28 million a year source there.
So it's about $40 million in terms of, $38 million in terms of a 3% franchise fee.
Who pays for that?
And the customers pay for that.
And the customer would
Understand that, right.
The customer would be, that would be added on top of the franchise fee. That
Sure, got it. Joey?
Chairman Shai, I've got the a 5-year look back on the franchise fee that I'd like
Would
to
you
just pass
distribute
out to
that?
them.
Okay, that's great. Super.
Chairman,
Okay.
to the committee, thank you very much.
Thank
for
you
your
very
time,
much.
and
This is
I
very helpful.
appreciate all the work you're doing.
Great. David Drain and Jonathan at Trichter. We have your slides, so, and these are important. We've got about 15 minutes. I know that's not enough time, but we're going to be back here next on the 12th, so we will have time to do that, because now we're sort of moving into the harder part, which is the pension, not the governance wasn't hard, the pension design and unfunded liability. So David, you want to just go through it real quickly with us?
Yeah, it'd be my pleasure. And I'll go through it as quickly as possible so we can have questions. And obviously, if there's more questions at the meeting on the 12th, I will answer them there as well. 3 questions for the task force. How do you have a credible and achievable plan to pay down the pension debt? How do you design the benefits going forward so they're sustainable, affordable, and secure? And then governance and other investment practices. And we did 3 analyses to try to answer shed some more light on those first 2 questions. One, looking at the different funding proposals out there, including the city's proposal from last week. Two, trying to understand the impact on workers' benefits of reducing COLAs prospectively. And then third, looking at how different plan designs might handle investment risk. So in terms of paying down the pension debt, we looked at 4 scenarios. 1, what happens if you simply pay the ARC going forward? 2, what happens if you have stable payments of $190 million each year? Third, what happens if you have stable payments of $225 million? And then lastly, looking at the city's proposal from last week. For all of these, new employees are assumed to go into a plan based around the MSP proposal. Current employees have their employee contributions raised to 10%. In addition, in the mayor's plan, COLAs are changed prospectively for current employees, and the additional piece of the chapter funds would be dedicated to helping pay the unfunded liability, as well as payments from the JEA. On a brief comment on the chapter funds, obviously there's a bunch of questions about whether it's legally or morally appropriate to use those to pay down the unfunded liability, or if it's legally or morally appropriate to use those to enhance benefits when the plan is 39% funded. That's not really something we're able to address. But in terms of how we think about it, and I mean, I guess John is gone, but he might find this a distinction without a difference. If you got rid of that, 4% and change that's currently going into helping the city's contributions, it doesn't go to employee salaries, it goes to employee benefits. So changes to that, really should be thought of as either as cutting employee benefits if you think that they're entitled to it, rather than thinking of it as contributions. So I guess we would disagree on kind of how he characterized it. So this is what costs look like if returns are 7% going forward. Green line is the ARC. The 2 purple lines are the stable funding scenarios. The blue line is the city proposal. Our numbers differ slightly from what was presented last week, because we're also including these JEA payments. So what the city looked at was simply the budgetary impact from the city's perspective, but in thinking about what are all the funds going in, we wanted to look at the JEA $40 million contributions as well. This is looking at the funding side of this, so if obviously there's a debate about whether the JEA is the best source. If you had a 1 millage increase, I think the rule of thumb we've been using is that's about $45 million. You could find it from other sources and maintain the same funding pattern. And the difference is, it's really, the city's proposal has about the same costs as the $190 million proposal until the plan hits about 80% funded. It's substantially below that for a number of years, but because the amortization period is extended to 30 years on this separate basis model, paying down the unfunded liability extends further out. Now, this is still well within best practices for pension plans, which typically say pay it off in 30 years or fewer. So, but it does extend out that payment period. It also avoids both the large spike and then the big dip. This is how funding changes over time based on this. I think the one thing to note is if you look at the city proposal, it grows fairly quickly until it hits that 80% threshold when those additional payments from JEA and the additional usage of chapter funds cease. And then funding levels increase, but at a slower rate going forward. This is simply the totals. And then this is what happens if returns are 5.4%. Now, under this we're seeing the assumed rate of return remains 7%. The actual returns experienced by the plan are 5.4%. Obviously, in a real scenario, if you've got 30 years of missing your investment targets consistently, we'd expect the assumptions to be changed at some point. But for modeling purposes, assumptions stay at 7% the whole way through. Looking at the ARC payments, they go up to a higher total. As expected, you're dealing with investment losses or actuarial losses from investment shortfalls each year. That $190 million payment, that $190 million ends up not being enough to be above and beyond the ARC, and so you end up having to make the ARC payments starting in around 2027 or 2026. The $225 million stays, at a stable rate until the plan is fully funded in, about 2036, and then the city proposal once again goes further out and has payments for the unfunded liability over a longer period. Note that because when it hits that 80% threshold, the city proposal, those extra payments stop, and the city proposal ends up having a fairly flat funding level going forward, unlike the other proposals, which more money is put in to get them to 100% funded. So those are our analyses of the different funding proposals that have been put forward. As said, the real difference between, say, the $225 million model and the city's proposal, one, there's additional costs that are going to be borne by current employees through the COLAs, and we'll talk about that in a bit. Two, it it avoids some of the spikes and drops, and three, it extends the payments over a longer period of time. And then finally, because some of those extra payments stop when it hits 80% funded, it means that if things do fall short, it may be hard it won't be as easy to make up the funding shortfalls that are already there. Now looking at plan design changes, we've heard discussed a number of changes for current employees, increasing employee contributions, changing or eliminating the drop program for people who aren't already eligible for it, and reducing COLAs prospectively. I want to talk a little bit more about the COLA changes. This is obviously part of the city's proposal, and this is it's a benefit cut for current workers. And then subsequently we'll look at some of the design, how different designs handle investment risk. So because the COLA changes are prospective, someone who's very late in his or her career is actually going to have a very small impact, if any. If you have 25 years of service in, you're eligible to retire or enter the drop, very little, if any, of your benefit will be affected by the COLA change. In contrast, if you're early in your career, if you're first 1, 2, 3, or 4, or 5 years, the majority of the benefits you earn will be subject to these new COLA rules, these reduced COLAs. And because the way it's set up is, any benefit I've already earned or accrued is treated under the current COLA, 3%. But any increases that from either additional years of service or from salary increases are treated under the 1.5% COLA. So if an employee, today has earned a $20,000 annual benefit, and then, when he or she eventually retires, the total benefit is $60,000. That $20,000 will be given 3% annual increases. The remaining $40,000 will only get 1.5% or CPI, whichever is lower. And so this is for a worker with 5 years of service right now. So this is someone who's going to be, relatively, is going to have more of an impact. The orange line is current benefits as they are. The purple line is the MSP plan, just to show in contrast to what a new employee would be getting under the mayor's proposal. And then the green line is the current benefits with COLA reduction. And it's a substantial decrease from the orange line. It's still above the purple line for most of an employee's years of service. And then finally, at a previous meeting, I showed the impact on contributions of either having a new final average salary defined benefit plan going forward, or a hybrid plan that blended a DB and a DC. And because really most of the liabilities are for current employees, there wasn't much of a difference to be seen. So this chart looks at what would happen to costs for new employees only. Everything already promised to current workers, everyone in the current system now, they aren't included in this. This is only looking at what a new employee would get, or what a new employee's benefits would cost. And if returns were only 5.4% instead of the 7% assumed. And you see by the end, as more and more employees are earning these benefits, and as the liabilities and assets have grown, annual costs end up, diverging. In 2044, it's about an $8 million annual difference. For most of those initial early years, you don't actually see a great degree of cost difference, even if there's investment losses. Part of it is simply that the asset base isn't that high. So if if you don't have a lot of pension assets invested, if returns fall short, you're still not losing all that much. As the plan gets more mature, as the asset basis increases, an investment shortfall relative to assumptions matters a lot more. And then the second piece of it is that because these costs are amortized over a period of time, a loss in 2015, I'm going to see a piece of that in increased contributions in 2017, a piece of that in 2018, but it's going to be a small amount each year. So as 10 or 20 years into this, you're starting to see the accumulated costs of those early year losses. So those are the three analyses I really wanted to share, and in interest of time, I think it'd be best to go straight to questions.
You had that same slide at 7% that you already produced, is that right?
Yeah, and the lines basically overlap at 7%. They're the plans are designed to be about the same costs, so if assumptions hold true, the lines will,
relatively equal on 7%, and then the difference is about 30 years out for the 5.4.
Yeah, and in contrast, so let's say returns were 10%. Obviously, that's a great scenario for the city and for the fund, so no one's really all that worried about how we handle that. But you'd actually see the hybrid plan cost more than the DB plan because the DC component, all these investment gains, there's going to employee benefits, and so the city's not able to contribute less because of it.
David, thank you for your analysis. On the number 8 slide, I'm really having trouble reconciling the numbers between the $190 million and the city proposal. For roughly 12, 13 years, they make the same payment, but for some reason, with the same rate of return, the $190 million payment goes to $400 million, and yet the city's doesn't grow. Are these calculations being done identically, or are we looking at apples and oranges?
So what are the differences? So one is that and really the most important difference is that under that $190 million, it's keeping that same amortization method. And that amortization method says, basically, in 23 years, we're paying off our unfunded liabilities no matter what. And so that's why you see under both the green line and the dotted dash purple line, that big spike. Because in 2036, there's going to be a payment that's going to pay off the existing unfunded liabilities no matter what. In contrast, the city proposal goes to this individual amortization, individual separate amortization basis for each year. And so, I think the real difference is, at the, under the $190 million, setup, the plan is fully funded in 2040. Under the city proposal, the plan is just 84% funded in 2044.
So the problem is, you've got a task force made up largely of non-financial experts. You're doing calculations differently. It wasn't clarified. It's not really a fair calculation because you're really in the city proposal on this particular page where the calculations were done, you're pushing out the paying down of the unfunded liability further. So it's not an apples to apples comparison. It's very misleading. If you instead use the amortization method for the $190 million, I think it would look very different. And then if you use the same amortization method for each of these calculations, then you can compare apples to apples, because the task force is tasked with doing this analysis, and this is very complex, and you've got to line it up so that you're using the same equation.
Well, and I think that's why using these these summary tables at the end is really the intent there was to try to put all these pieces together to say that.
Well, then what I read from that is if we pay less over time, we're going to owe more in 30 years. I would agree. But the problem is that this is showing us paying less, and that's not what we're looking to do. So we just need to agree, are we okay with 84% funded in 30 years, and that would be fine. Then you wouldn't be having the spike in payments on the $190 million if the amortization is identical.
Yeah, and one of the changes that the city proposal did from how things are now is changing the amortization method.
Well, and I think some of that came up here, which we agree with because it avoids the spike. But we need to see graphs where it's apples to apples
Yep,
comparison.
that was my question too, because if you use the same amortization process or method, those would look a lot different, because you've got the 23-year compared with the, take it 30 years each year, which is, I thought, where we were moving with David's proposal from before.
Yeah,
So
and-
it might be helpful to redo those on that basis.
I'll make that change.
Okay, right.
Yeah, and I think you're right. Page 8 is the place to focus, and just to think it through for a second. So what we wanted to answer with page 8, Charlie asked the question, well, that's great if we start off at 220, but is there a little bit of balance we ought to be having in that view, right? So what we hope to be able to form a view on with slide 8 is if we start off at different payment levels, and good things don't happen, but the lower reasonable expectation does happen, 5.4, what kind of trouble do we get in, right? So let's leave the city proposal out for a second and just look at the other three. So what we're really saying is the amount that we can fund might be up for debate, but we took 120 plus 70 and said, hey, let's pick 190, right, as a funding level that seems to be a number you could grab from some source. And what this would say on the 190, the dotted line, is that unless you adjusted your funding schedule, you would end up in a year with having to have over $350 million in payments. Now, we would never do that, right? We would say what's really going to happen is you'll start off assuming 7%, you'll only earn 5.4, and then at some point, the light turns on. You say, this isn't working, guys. We really have a much higher responsibility than what we're putting in here, either because we're actuarially required or otherwise. And so that dotted line will automatically then shift up, right? And I think the question we're trying to understand is, what's the risk we take by putting ourselves into a requirement to have an annual funding level that we can't afford if we don't start off with the safe level, which we said was 225, assuming we want to go to level funding, yes or no, is our first decision. Do we want to have our funding pattern go up over time, or do we want to sort of do it amount that we can budget and stick to, right? And then if we're going to have a level funding standard, which the subcommittee recommended, then do we set it at a level where we sort of aggressively pay more to make sure we're never surprised, or do we take risk and pay less? And so what we need help understanding is, if we take risk and don't pay as much as the subcommittee recommended, what kind of trouble can we be in if we rely on the 5.4 as our lower boundary? Right. And so that's what we're trying to answer. And so this slide says you can't do it, but it's because it allows things to go up to unreasonable peaks. And so really what would happen is, at some point, either actuarially or otherwise, you'd be forced to take your payment levels up so that you're always still contributing to put some of your unfunded liability behind you, right? And maybe it's a matter of judgment as to where that happens. But that's what we're missing a little bit. And yeah.
I agree with John's point. Really, the question here is it okay to amortize those things over 30 years, which spreads the tail of that payment out? So if all these schedules show, if we agreed that that was okay, and all these funding proposals were measured under the same, then I think we'd be able to see what really happens.
I agree with that, yeah.
And maybe we ought to take a view on that. I mean, that would help David out. I mean, what is the consequence of allowing the period to pay it off to be extended? I mean, I think, the big principles we had were that, I think as a collective body, we wanted to put some of the unfunded liability behind us, right? We don't want to pay the minimum and have, but do we mind not being fully paid off? Would we take a 40-year mortgage instead of a 25-year mortgage? Well, I think we'd be willing to consider, I offer, longer mortgages, as long as we know we're not taking risk with respect to getting into a plan we can't afford.
Right.
Is that fair?
Right.
Yeah.
The city's plan is perfectly acceptable with regards to the amortization method. We just need to match up the amortization methods and make sure we're comparing.
So that I understand it, and I'm one of these people that is not, I'm one of those you described. So as I understand it, if you put the 30-year, every year look on all of them, that would help us make that decision.
Smooths it out.
Right, and I hear David asking, are we okay, and I guess we don't really know until we get the number, with going to that spreading out, and I thought we were,
Yeah.
And that's the way the fund used to do it, and they just changed it 2 years ago, and we would ask them to go back.
Well, no, that's a separate, the word amortization is confusing us. Yeah, it's not, that's a smaller point. The bigger point is, do you set a hard target when you're going to be 80%? And so and David has assumed, thinking that's what we wanted, I guess, that, hey, no, we're going to force it to be paid off by 2036. And if you want to do that, this is what you got to do. And what's different, to John's point, is the line for the city's proposal allows it to say, well, okay, I'll just refinance and do it over another 10 years. And
And we would, I think, appreciate the perspective from Pew and the MAVA group, but I think what we're hearing is we're okay with that.
Yeah, that is it's a good practice. It, corresponds with the key best practices of do it within 30 years. It avoids some of the problems with, say, having that spike and that dip. So, we both agree with that approach and then would be happy to work to readjust these.
Am I sensing that the committee is okay with that approach?
And just to restate what that is, so you're saying as long as you set a boundary at some point, because, right, so 30 years your boundary, but take up to the 30 years, don't take a 26-year or a 24-year type of thing. That's what we're suggesting, right?
But help me understand, because you said what I said was a different issue, because I thought it was related to the 30 years each year.
Yeah, your question was, if you make money or if you make more or less than your assumption, how quickly do you cause that? If you lose money, how quickly you have to put it back in? If you make money, how do you spread it? And I think that's different from this question is what's a hard date to be funded?
Okay. Thank you. Greg?
Just a quick question. So is the rationale that you're trying to match up how long somebody's going to work? Is that 30-year period? When you're trying to amortize that liability, shouldn't it be over that lifetime of that employee, or does that matter in this case?
One of the goals is, obviously the starting point is to try to be full funded, because one of the problems with being underfunded is you're basically telling future generations, you need to bear the costs of past generations' actions. But if you're 39% funded like Jacksonville is, you've already blown past that. So then the question is, you don't want to kick the can down the road indefinitely. You do want a set period. So piece one is, how long do you want that period to be? And then the other question, so, do you want it 23 years? Can you extend it out to 30 years? What makes sense? And 30 years is the typical practice within state and local pension plans. Somewhat picked arbitrarily, but, it's at least, you don't want to do it over too short a period. It ends up being very burdensome. You don't want to do it over too long a period. You're then just never dealing with your unfunded liability. 30 years is, practitioners have decided that seems a reasonable target. Then the other
Bob, should Mr. DeZubi say, do you want to say anything at this point before?
I just wanted to elaborate and remind the committee that the 30 years is from state law, and that when he combined all when the police and fire actuary combined all the bases, the 23 years came from his understanding of state law. It was not like he could have combined them all and gone to 26 years or 28. Right. It could be no more than 23. And that each additional base in the future can be amortized over no more than 30 years. It's pretty standard practice. The only rule we really want to look at is that if you have gains, you can't say, I'm going to amortize them over 10 years. If I have losses, I'm going to amortize them over 30 years. You have to treat everything consistently.
Does that mean that the city's proposal is not in conformance with state law?
No, the city's proposal is, because it goes back and each base is being amortized over 30 years from when it was first established. It's kind of ignoring what the actuary did in 2012, going back to his 2011 practice. And so one of the reasons why it's later is you had big losses in 2011. That was the first time they recognized the Great Recession and the assumption changes. So when you went to 23 years, you're paying it off faster. When you pull them apart, the losses from 2011 are done over 30 years, which takes you out to 2041.
Okay. Ted, then Bob.
Yep. David, one of the things, I think slide 12 here is, I think, an attempt to respond to what, since Kirsten's not here today, it's been her question, and she's brought it up, I believe, almost every meeting. and I think it would be helpful to us, but this doesn't quite do it. What I think she was trying to get to, and I think it would ultimately be helpful for this task force, is to say, okay, let's look at the various different aspects of changes to the pension plan that have been proposed, both in the mayor's proposal and other proposals. If we change, for instance, the cap on pension benefits, I know is going to have a negligible effect. I mean, it may have a $10,000 effect on the fund or something like that. But what would the COLA change from 3% to a max of 1.5%? What is that going to actually save us? Because we're trying to come up with a design, and if we're doing things, I understand the idea, the concept that we want to have some shared sacrifice from the employees, but what we don't want to do is unnecessarily create a great amount of difficulty for the employee when, or substantially harm the employee when it doesn't really help our bottom line. So what I think we need to do is say, if we make this change to the COLA, it's going to save us X number of dollars. If we make this change to the drop plan, it's going to save us X number of dollars. And what is that going to do to our overall recommendations here? Is it possible to do that?
Both of those, I believe, have been done by Robert and by Milliman, so as part of their modeling for the city. So
can we
we
just
get those?
numbers?
Can we get that?
We started doing a lot of this probably even before they did the mediation a year ago.
Right.
And we did a lot of separate items. The issue you have is that so we have not done anything based on the 2012 and what everything's based on separate. The issue you have is when you take them all apart one by one, the sum of them do not equal the total. Because if you change, as an example, if you make people retire later, the value of a COLA goes down because they're going to get it a lot less. So one of the issues we always had when we were trying to do them separately and then put them together, or the other way is, tell us the order you want them evaluated. So I guess I'm trying to say here, we've done some work where we've taken the base plan and compared it to the mayor's proposal, but the only difference for current employees, the difference is the 3% employee contributions plus the COLA, so that part can be broken out. But for the future employees, we really have not done anything in over a year where we looked at each thing separately.
Can we get that data? Because that's, for the future employees, I don't think are really too much of an issue from what I've heard. But if we can get the figures for the mayor's newest plan in terms of what are the cost savings for implementing each of those different, aspects of it, I think that would help us out greatly.
Well, so for the purposes of analysis, would a fair basis be that whatever was already agreed upon in the original MSP remain, and that the other variances in the new plan be the incremental comparisons?
Okay, let me go back a step earlier. If I look at the gross normal cost, which is really the value of the benefits being accrued, between the mayor's plan, the MSP as currently envisioned today, and the base plan, the gross, not some, but it's before I'm netting out the employee contributions, the only difference is the change to the prospective COLA. And then, so you have a gross normal cost, you can tell the difference. Then the next line is the change in the employee contributions. So it would have those two things separately.
Would you also have the difference in the drop? Because he did make a recommendation to the interest rate for the drop.
We haven't done much with the drop, mainly because the police and fire actuary in 2011 did not adjust his results for the value of the drop. We're trying to start with his numbers. And in 2012, he came out when I had talked to him, so this would have been 6 months ago. He had just loaded the numbers a little and for the present value benefits, but not for the normal cost at that point. So we were trying to base our numbers on his. So we're not going to have much of a showing. I think the difference in the drop propose is really in the rates of return. You have to look at what your rates of return are going to be, and if they do average 10%, or, so that's more, you can look at individual people, what it's going to do. The Pew Actuary had done an analysis on drop, and we looked at it, and we fooled around with it just to see the impact and, the investment return, and this is just on one hypothetical person. Also the pay raises, which I think are really a big item. If you go into drop, you're giving up 5 years of pay raises. Again, if you're not going to get any pay raises, drop looks really valuable. If you told somebody he was going to get 5, 6, 7% pay raise a year, he's giving up 35% in pay raises. He's probably drop is not nearly as attractive, even if you give him a high rate of return.
Okay, Bob?
Yeah, I just want to make an observation about slide 8, and that is, we said we want this to be sustainable, and it has to be reasonable. And so I think if we look at the purple line, we can see a sustainable and reasonable, I guess, is to remove the peak and remove the cliff. So we can look at the purple graph and see that making higher fixed payments results in removing the peak, and the 30-year amortization would then remove the cliff. So I think that is a reasonable approach for us to take.
Okay. John?
It seems hypothetical if we don't deal with the revenue piece. I feel like we're back to the governance discussion where you got to understand the basic principle here. But what I've heard today is that the fund doesn't see any opportunity for us to address the shared piece of that, the reserves that are part of that. I've heard JEA, maybe I misread that, but based on that is that it's nowhere near $40 million. The administration says they don't want to tax. So I'm trying to figure out what are the arrows in the quiver that allow us to even get from 190 to 225, or it's just theoretical?
I don't think it's theoretical, and that's what we're going to be doing at our next meetings is taking, well, what is a millage increase? What's the franchise fee? What's the JEA? And we're going to have to say, if we want to do this, if we want to get to 190 from 120, that's $70 million. That's essentially a little under 2 mills. Or
Is the base 120 or 148 that we're dealing with?
148.
it's 148, right?
Well, yeah.
That's what it was this year.
Yeah.
Right, right.
So, I mean, that's a 28 million.
Right. Right. Carl?
Is inflation in these numbers?
Nope.
I think that's important because if you actually, if we could establish 190 or 200 and consistently stay with that number for 15 years, from a quality of life standpoint, in terms of the city council and the mayor and the budget, inflation will occur. So you will be getting more revenues, and yet we will have set the payment schedule, so the stress on the budget should be, the stress will be there because you're going to have to come up with the 190 or 200 million. Right. But I can see that 10 years, 15 years out being a real bonus to the city to have that set, be being repaired as we go, and then as revenues grow, more will be able to go to libraries or whatever.
Right. But is that too short a period? Looking at these, it takes,
it may be
it's longer, right?
But I'm talking about the theory of setting the payment at more than what we need, and then taking some of the pain out of it. Because every year that comes up again. This summer we're going to be right back in the soup again, talking about closing libraries and not filling potholes and.
That's exactly right. And whether it's the 190 or the 220, essentially the 7% of the 5.4, where do we see pots to help the city council get there? And they may not like it, and the mayor probably definitely wouldn't like it if we say, well, the only pot we see is a millage increase. But if that's all we see, that's all we see. And
well, how do we get some analysis on all of our alternatives for revenue? Wouldn't we need to look universally rather than just focusing on one or two things?
I don't know what you mean by that.
Well, maybe we should spend some time at looking at all of our options. We've got the millage, we've got the utility tax, we've got squeezing JEA, we've got who knows, closing libraries, parks. Let's just see what those list of options are and determine as a group what we think are the most palatable.
I had some questions about that too, in terms of, does this task force really want to go that far? I mean, do we want to make our charter to also solve the funding issue, or to say, look, if we might have a recommendation as to whether 225 or 190 is the right way to manage it, but somebody's going to have to make trade-offs. Either you get there or you don't. But are we going? I don't know.
I don't see us deciding about the parks and all that. I see us. I've always viewed it as we come up with our number, and we say, well, here's some pots of money that we see.
Yeah.
Of course, cuts are always an alternative, but that's all that I think we can do.
Okay.
So, John, I don't think we need to get. We're not the city council. That's their role.
Or the mayor.
Or the mayor, right. So, do y'all agree with that?
Yes.
It helped me understand. It sort of frames it. If we ask David to come back and model the 190 and the 220 and a 30-year payout,
Right.
That gives us some parameters
Right.
within which to make a decision. Is that something we want to charge them with now?
Right, and just help us with maybe, guide us with a little bit of season's judgment on this, okay? If you're always willing to extend your amortization period, you never pay, it's sort of like the national government, right? You just add it to the deficit and you don't worry about it, right? It's pay as you go. And so the 30 years is a discipline. And are we unwise in thinking about 30 versus 25? And as long as we're not unwise, that gives relief to the needs to come up with funding. It seems appropriate to do that. I mean, are we missing something there?
No, I mean, this is, that 30-year, the liabilities that are unfunded liabilities, the pension debt that Jacksonville is facing today, under this approach, 30 years, they're gone. Now, if there's other losses in subsequent years, if there's investment shortfalls, if there's benefit increases, then obviously you need to deal with those as they come. But extending it to 30 years is, in accordance with Florida law, in accordance with typical practice, is considered a reasonable period of time to deal with it.
Right, so not to prejudge any answers, but the longer you make your amortization period, the more you want to really rely on things you can accomplish.
Right.
Otherwise, you're not paying attention to what's really happening, right?
The risk of the investment is very important.
Becomes more and more important, right, the longer that goes.
Which is why the 5.4 is important. I did want to ask the committee, I just want to be clear, we're going to make recommendations on everything except the hardest issue, which is where the money comes from. So we're going to punt on the hardest part, which has kept the city from moving forward all these years. Is that our?
No, John, that's not what we're doing. We don't know. We have the pots that have been presented to us and will be presented to us, but we're not going to be able to tell the city council, go raise the taxes. But we're going to be able to say, you can raise the millage rate and this is what you get. You can raise the franchise fees, this is what you get. You can get the JA to contribute this. But no, we're not punting on anything.
So we're going to examine all the options and lay them out.
That's my understanding. That's my intent. But that's all we can do. Bob?
I think we can definitely define some characteristics of the funding stream necessary to achieve the plan we're going to put down.
And perhaps analyze the impacts of the funding streams to the community and to the citizens in the community and the taxpayers and to the business.
That's more.
I don't see that. Right.
Let me just ask something. While they're modeling these different payment structures, should they also, because really, if we look at the mayor's plan, we're making recommendations as to possible income streams. So we're doing that for the 190, for the other levels of funding.
Right.
Can we also do that for the mayor's plan? Because frankly, we don't have control over whether or not that JEA money comes in, and I'm not sure who does.
Right.
But really, the mayor's plan consists of a plan for funding the unfunded liability, and however he gets that money is ultimately up.
That's ultimately true.
Yeah.
That's right. The way I envision it, we try to come up with the number of 190 or 220 or whatever the number is.
Right.
And then we say, here are some of the pots of money that have been presented to us. So City Council, that you have these options as we see it.
So when they model this, I think they should also model the mayor's plan, not with regard to the amount of where he gets the money, but the amount of money being
Correct.
invested into it.
That's exactly right.
So in fact, the blue line is, if you earn 5.4 and you pay 160 million a year roughly, which was the mayor's, if you're willing to go out to 2044 to be done, you can make that work and not find a problem. And this may be beyond what you've done, but an important thing here is we don't find ourselves in a situation with markets going up and down we're thinking that because we're overfunding through level payments, we have buffers that say, no, we're going to pay the 160 or the 190, we're going to do it, and that's all we're going to do. We're not going to find ourselves where a series of adverse markets say, that's still not enough, right? We're counting on that being a reliable outcome by going with a level payment stream that we're committing to. And so this assumes a simple compound rate of 5.4. Are there a series of scenarios where, yeah, you're going to earn 5.4, you could be 75% confident of that, but you know what? You could have 10 years where you don't earn anything. And if you do, your prepayments aren't enough. Do we have those kinds of exposures?
Well, and I mean, one thing that is already built in is because you've got, whether it's 23 years or 30 years or whatever, you've got, a buffer against any one or even a couple bad years, instantaneously forcing you to rapidly raise contributions. So there is that level of buffer, but yeah, obviously it's not going to be a static set of returns no matter what. It's going to be ups and downs.
It's going to go up and down. Right. Greg?
I just want to make one point. So I think the committee is doing exactly what I was hoping, which is to sort of scope out the problem, identify the bumps along the road, and then begin to provide some suggestions. At the end of the day, we are going to come up with sort of a number, right? And we've already we've sort of coalesced around what that number is at this point. But I can tell you, I think the people who can provide the most credible input is the administration right now, because they know what options are available for funding. They've already presented one option. There were some concerns about the option that you heard today. But why wouldn't this group, Mr. Chairman, why wouldn't we ask the administration to come up with an idea what options are available and how would they rank those options? I don't know why it's this committee's job to do that, and frankly, the council, we're really set up to look at those.
That's a fair question. I think if we can, I think you can imagine the ranking, millage increase, what we've heard before, rate increase, franchise, it's going to be 0, 0, 0. But that's where we have to use our judgment on that. Notwithstanding that, but I see what you mean.
My point is the administration needs to.
Needs
they've
to.
got more tools than anybody at this point.
Right.
And
I will ask them to do that. Okay. Okay. I think we've got. David, are you comfortable with your instructions for our next meeting?
Yeah, I mean, I guess just one question going forward. So happy to do it either way, but do you want these figures adjusted for inflation or unadjusted? Unadjusted.
And 30-year amortization for all.
Okay. All right, and then we'll ask Joey and Ronnie, ultimately, I guess, at our next meeting, we would like to see what all the baskets are as you see them. Notwithstanding that they may not be from the administration's perspective doable. Okay?
And to address one of Mr. Hand's questions earlier, Wells Fargo is not interested in participating in the revenue source, Mr. Hand.
Oh, I didn't see Chris. I didn't see Chris over there. I should have addressed that question to you, but that's what we would like at our next meeting. Are we done for today? We have one formal thing we have to do. Then I think we're going to need one more meeting, at least. In addition, we got our meeting on the 12th, but we've gotten a big chunk done with the governance, and now we really do have to focus in on the dollars and the pension design. So let's set a next meeting. If the next one is the 12th, if we went out 7 days more, what about the 19th? I can't do it on the 19th. How about the 20th? How about the 20th from 9 to 12? 20th from 9 to 12. I hate to go out another whole week.
I cannot do that day, Bill, but
You can't do it on the 20th?
I cannot.
All right, well, don't do it then. How about the 18th, which is a Tuesday?
You're going to run into committee, so you could do it in the morning, but.
Well, let me go back to the 19th. I've got a doctor's appointment, I'll just change that. So the morning of the 19th.
Can we do it after lunch so that if we run late again, we're
Yep,
not
and
eating
you want to
into the
do
rest
it
of our day?
at 1 o'clock? 1:30. Well, I've got to speak at Rotary that day, so I
How
can't.
about 2 o'clock?
2 o'clock, 2 o'clock on the.
February 19th.
February 19th. 2 to 5. 2/19, 2 to 5, okay. Carol, if you'll hopefully get this room. So it's the 19th from 2 to 5.
Bill, I'm not sure if you can make the 19th. I think we could do either the 20th or the 18th.
How about the 21st, which is a Friday? No, okay. All right, well, let's go into the next week. How about the 26th? That is a long, gosh, I hate to wait that long. 26th from,
That works.
I can't do it, well, I can change something then, so we could do it from 9 to 12 on the 26th. Is that okay, David?
Do we not want to do the afternoons to try and spare our schedules a little bit more?
That's okay, 2 to 5 on the 26th? 2 to 5? Okay, 26th from 2 to 5. Okay.
Can I ask one other thing to the deliverables? So we're going to get this with the amortization schedule. The other thing that I think we had asked for that might be helpful is when we talk about, one way is the size, size of the buckets. Another way is just to understand the normal cost. And so the city said, the subcommittee said, the way you sort of understand what you're doing is to consider the normal cost of the benefit, right? So if we had a way to talk about, so that, what are the normal costs, and we'll be measuring at 7%, I think, right? But the other piece might be to say, well, we're counting on 5.4, so we ought to really price it at 5.4, although we expect it to be 7. So right? And maybe it's just a directional estimate.
Are y'all nodding yes?
The 7% is definitely doable. The 5.4, so what we've been working on is doing the base plan, the MSP, split it apart for current and future hires, and the hybrid plan, current, future. We have to go back then and rewarn. It's a lot of work.
How about just the new employee piece at the, we thought the new employee, I think, was about 12% or something, right?
At
7.
It's a tad under.
Yeah, but so why do we care? Well, let's say that the new employee benefit plan, when measured at 5.4, which is what we're willing to count on, costs 20%. Then for purposes of comparison, if we were really indifferent at that, we could put in place a very generous defined contribution plan and pay the same amount. And so all those kind of issues. So that's where it becomes relevant to understand what's it really costing us.
Just the MSP, just the mayor's proposal.
Yeah, I think, yeah.
Future hires at 5.4.
Yeah, because if it's a lot of work, at least it's perspective is what it, right?
All right.
Mr. Chairman, is there nothing in the work of the week of the 17th that works? I'm just in the interest of trying to make sure the entire city team can be here, and I know the task force is trying to wrap up its work as well.
Yeah.
Is that week entirely out for the subsequent meeting?
Well, how about, we could say Monday the 17th, or Tuesday the 18th, or Thursday the 20th. Bob said he couldn't be here on the 20th. 21st is a Friday.
I can't do the 18th or 19th.
Or the 19th. So how about the 17th, which is a Monday, if we did that from 2 to 5?
That works.
17th, 2 to 5?
You want to do 1 to 5?
1 to 5, 17th, 1 to 5?
President's Day?
17th, in fact, you're right, 17th is President's Day.
Well, does that matter?
To the extent permitted by law, we will happily open City Hall if the task force wants to meet that day. So,
How does the president feel?
I don't really, right. It's Lincoln and Washington. They don't really care. How about it?
They'd be glad we were meeting.
Yes, the 17th, notwithstanding that.
If we're going to do that, are we going to do it in the morning? I'd rather do it in the morning if we're doing that.
If we're doing that, the morning, 9 to 12, that means David and Michael Jonathan have to come down the night before that.
Well, never mind that.
Let's do it from 1 to 5. 1 to 5 on February the 17th. And let's leave the 26th from 2 to 5 just to get it on our calendar. 17th, 1 to 5. Okay? All right, so that's good housekeeping. All right, now we have to have public comment, which we are glad to have, but we've been through a lot, and we don't want to have any repetition. And we know about how bad certain things are from certain perspectives, so I'm hoping we can avoid it. Anybody want to speak? Mr. Lee?
I won't do it.
You've got 1 minute.
All right. First, I worked for many years in corporate America on pension matters.
You've told us that.
COLAs are hugely costly. That goes to Tad Delaval's point, and of course, drops do not exist. Second, tying the electric rates in with PFP costs is a bad idea because once it's done, it will probably never get undone. Third, I never understood Mr. Keene's math. Chapter funds are around $10 million a year. The employees contribute around $10 million a year. The city contributes $148 million a year. There's no way the city employees, even if you count the chapter funds, which are taxes, not their money, there's no way city employees are contributing over half. Fourth, you should know that Kirk Sherman's office discovered a $129,000 overpayment many months ago. And recently, the PFPF has discovered another $60,000 in overpayments to 3 pensioners in total, which leads me to have serious doubts, again, about the competence of the PFPF as it currently exists.
Thank you, Mr. Lee.
Again, the JRS should manage it. Thank you.
Thank you. And I'll just point out that that's been referred to the General Counsel's Office for recollection. So, okay, any other business? Motion to adjourn? You're adjourned. Thank you.